No, no. No. Yes. Oh, kami coba dulu na once
ये राशि तो खाना का 430 तो बुक है
For orders, item number 1.
Please, my lordships. So I have decided that I have finished my submissions and I raise my case before this honorable court.
Anyways, we fixed the matter today only for delivery of judgment.
Lordship.
This intra-court appeal arises out of the judgment on order dated 24/11/2023, passed by the learned single judge in WPC number 339 of the 2022, whereby the writ petition was dismissed on the grounds and reasons stated therein. For the purpose of deciding as regards the legality and validity of the said judgment and order passed by the learned single judge, we find it relevant to take note of the brief facts of the instant case. On 27th of October 2008, a notification was issued by the Additional Chief Secretary to Government of Nagaland whereby which related to the state policy on recruitment of teachers under the Department of School Education, Government of Nagaland. It was stipulated in the said notification that candidates who do not possess the prescribed professional qualification there will be a relaxation in respect to the conditions stipulated therein. It was also mentioned that the said relaxation shall come into force with immediate effect, and the said shall continue for a period of 3 years, which shall be subsequently renewed either for extension or discontinuance. Subsequent thereto, another notification was issued on 18/2/2010 by the Additional Chief Secretary to the Government of Nagaland, wherein the relaxation in respect of candidates for the post of postgraduate teachers in higher secondary schools in the states who did not possess the prescribed professional qualifications were enumerated. Amongst the various conditions enumerated were that every selected candidate on appointment shall undergo the prescribed profession course or B.Ed and shall complete the said course within 5 years in respect of candidates belonging to the backward tribes of Konyak, Konak, Sheng, Siam Mungan, Yumchur, Sangtam, Hom, Chakachang, Pochuri, and Jiling, and within 2 years in respect to the other tribes. Further to that, it was also mentioned that the order of relaxation shall be deemed to come into effect from the date of the issue of the first notification relating to relaxation of the recruitment policy, vide order number dated 27/10/2008, and shall be valid for a period of 10 years in respect of candidates belonging to the backward tribes of Konyak, Chang, Siangmungam, Yamsur, Santam, Hom, Chakesang, Pochuri, and Jeleng, and for 5 years in respect to other tribes. Pursuant thereto, a significant development took place in as much as prior at the time when those notifications were issued, there was no service rules. There were no service rules, no madam? There was no service rules. Huh? These were executive instructions. Significant development took place in as much as the Nagaland School Education Service Rules 2017 was brought into effect. These rules are the rules have been framed in terms of the provisions of Article 309 of the Constitution. Full stop. The Nagaland School Education Service Rules 2017, hereinafter for short referred to as the Rules of 2017, stipulates the rules for regulating the recruitment and conditions of service of persons appointed to the Nagaland School Education Service. Rule 5 stipulates the method of recruitment. In terms of the said rule, the method of recruitment to the post of Schedule 1 shall be either by way of direct recruitment or by recruitment from lower grades or by promotion or by selection through limited departmental examinations. In Schedule 2 to the rules of 2017, the respective quotas reserved for direct recruitment and by promotion, the qualification and conditions for direct recruitment and for promotion or placement to various grades of the service have been enumerated. We are concerned with postgraduate teachers. Postgraduate. Rule 6 stipulates, Rule 6 capital A stipulates the direct recruitment process pertaining to the postgraduate teachers. In terms of subclause 1, Roman 1 of Rule 6 capital A, the department shall send a requisition form prescribed by the Commission indicating the subjects or academic disciplines and the number of vacancies which have arisen or were expected to arise in the service, which fall within the purview of the Commission. Thereupon, on the basis of the said requisition, in terms with subclause 2, the Commission shall advertise the post, specifying as far as possible the terms and conditions under the rules of 2017 and the number of vacancies to be filled up. On the basis of the said requisition, on the basis of the said advertisement, in terms with subrule 3, subclause 3, a candidate must apply on or before such date and in such manner and in such form as may be prescribed by the Commission. Thereupon, there would be a written examination which would be followed by an oral interview as stipulated in clauses Roman 4, subclauses Roman 4 and Roman 5. It is, however, very interesting to take note of subclause 8, which stipulates that on the base, what would be the consideration for granting marks on the basis of the academic records, amongst the many, it would be seen that at serial number E of the table stipulated in subclause Roman 8, 30% of the aggregate marks, weightage of 30% of aggregate marks would be given on the basis of the B.Ed examination. At this stage, this court further finds it relevant to take note of Schedule 2. And more particularly, to the educational qualifications required for postgraduate teachers, bracket junior grade Roman 3, as stipulated in serial number 8 of the higher secondary cadre. Taking into account its relevance, the same is quoted here in under. It will open up page 31 of the From the above quoted portion of the Schedule 2, it would show that in respect to direct recruitment of postgraduate teachers, junior grade 3, the postgraduate teachers, the postgraduate with at least the candidates must be a postgraduate with at least 50% marks, bracket, or an equivalent, bracket close, relaxable by 5% for scheduled tribe, scheduled caste, differently able candidates at the master degree level in the relevant subject from a recognized university, and shall also possess a Bachelor of Education, bracket B.Ed, bracket close, dot B.A. dot ed oblique B.Sc. dot ed from any National Council of Teachers Education recognized university. It is also seen that in respect to those candidates who would be recruited from the lower grades also, there is a requirement of having the B.Ed oblique B.A. dot E.Ed, B.Ed oblique B.Sc. B.Ed, and have rendered a continuous service of 7 years as graduate teacher or a primary teacher. This court further finds it relevant to take note of another rule, that is Rule 32, which stipulates the power to relax rules. The said rule, being relevant, is reproduced hereunder. Next. A perusal of the above quoted rule would show that when undue hardship is likely to be caused to any person by the application of these rules, the governor shall have the power to relax the application of that rule in respect of that person for good and sufficient reasons, which shall be without prejudice to the interest of any other member of the service. Therefore, a reading of the said rule makes it very clear that the relaxation in respect to the requirement can only be exercised by the governor, and that too only after the rules of 2017 had come into force. This aspect is relevant which should be seen from the later segments of the instant judgment. In the backdrop of the above, the facts would show that an advertisement was issued, and the facts would show that the respondent in the Department of School Education submitted a requisition to the Secretary Nagaland Public Service Commission on 27/8/2019 for filling up a post under the government higher secondary schools under the School Education Department. The format of requisition for the direct recruitment was also enclosed to the said communication. It was specifically mentioned that the said advertisement would be in terms with the rules of 2017. In clause 5 of the requisition, it was specifically stated that the educational qualification required would be postgraduate with B.Ed. However, there would be relaxation for maths and physics in respect to B.Ed in terms with the OM number EDS/HSS/4-1/2008 dated 19/8/2016. The number of posts, the vacant post against which the advertisement was to be issued was also mentioned in the requisition format. Pursuant thereto, on 13th of November 2019, the Nagaland Public Service Commission had issued an advertisement number NPSC-3.
Sorry for indulgence, but Your Lordship, we have made two requisitions. One is on 27 August 2019, and the second requisition is on 10 October 2019.
Had made two requisitions.
Yes.
Dated. The first is
27/8/2019 and 10 October 2019.
but the conditions are same.
Same.
Pursuant thereto, an advertisement was issued, being advertisement number issued by the Nagaland Public Service Commission, being advertisement number NPSC-3/2019, dated 13/11/2019. In the same advertisement, at serial number 27 at serial number 27 to 32, various posts were advertised in respect of postgraduate teachers under government higher secondary schools under the School Education Department. At serial number 33 and 34 of the said advertisement, postgraduate teachers under the School Education Department in respect to maths and physics were also advertised. The said advertisement contained a relaxation clause which stipulated as under page 75, relaxation for educational qualifications. 1 and 2. Thus, page 75, 1 and 2. From the said quoted relaxation in educational qualifications, it would be seen that in respect to that in terms with the notification dated 18/2/2010, which have been already referred to herein above, candidates not possessing prescribed B.Ed qualification, relaxation shall be admissible to candidates belonging to backward tribes of Konyak, Chang, Sinun, provided the selected candidates complete the said course within 5 years. There is also a B.Ed degree relaxation in respect of PGT, in respect to postgraduate teachers in maths and physics for a period of 5 years on the condition that the selected candidates should acquire B.Ed within 5 years of appointment, failing which further promotion, service confirmation will not be given and the increment stopped as provided in the new training policy. This was done so on the basis of another OM dated 16/8/2016. On the basis of the said advertisement, the duly participated in the said recruitment process. Admittedly, the petitioners herein, the appellants herein duly participated in the said recruitment process. Admittedly, the appellants did not have the B.Ed qualification. Subsequent thereto, a notification was issued by the Nagaland Public Service Commission on 8/7/2022, wherein which showed that the appellants herein were selected against the posts which were advertised. And thereupon, by the communication dated 18/7/2022, the Nagaland Public Service Commission had made the recommendation for appointment of postgraduate teachers, which included the appellants herein. Pursuant to the issuance of the said recommendation, on 11/8/2022, the Joint Secretary to the Government of Nagaland has issued a communication to the Secretary Nagaland Public Service Commission stating inter alia that appellants herein did not possess the requisite professional qualification B.Ed necessary for appointment under the School Education Department as per the Nagaland School, as per the rules of 2017. It was also mentioned that as per the requisition submitted, there was a relaxation in B.Ed training for maths and physics only in terms with the office memorandum dated 19/8/2016. Under such circumstances, the Secretary Nagaland Public Service Commission was requested to clarify as how the three candidates without having the requisite training of the professional qualifications were recommended and the anomalies be rectified. To the said communication, the Secretary Nagaland Public Service Commission issued a communication to the Commissioner and Secretary to the Government of Nagaland School Education Department dated 23/8/2022, stating inter alia that there was a clerical mistake committed at the time of releasing the advertisement. However, it was stated, however, a request was made to the department to consider the matter as an unintentional error and initiate for relaxation of B.Ed as a basic qualification for recruitment to be extended only for this particular year, that is 2019, for a logical conclusion. To the said communication, the Joint Secretary to the Government of Nagaland again informed the Secretary Nagaland Public Service Commission by the communication dated 19/10/2022 that the requisite qualification for the post of postgraduate teacher is postgraduate with B.Ed. The Right to Education Act 2009 also clearly mandated appointing teachers with the requisite entry and academic qualification. It was also mentioned that as per the opinion rendered by the Law and Justice Department, if any advertisement is inconsistent with the recruitment rules, the rules would prevail. Taking into account that the respondent authorities, more particularly the respondent state government, did not adhere to the recommendation, and on the other hand, was not appointing the petitioners, the appellants, to the post where they have been selected and recommended, the petitioner, the appellants, preferred the petition before this court, which was registered and numbered as WPC number 339/2022. Pursuant to the filing seeking the reliefs inter alia, that the respondents in the state government be directed to consider the letter dated 23/8/2022 issued by the Nagaland Public Service Commission and to appoint the petitioner as the postgraduate teachers in English, computer science, commerce, and commerce subject as per the advertisement, as per the recommendation later dated 18/7/2022. Further to that, the petitioners have also assailed Clause 4 of the notification dated 18/2/2010 to the extent of giving relaxation of policy in respect of postgraduate teachers with retrospective effect from 27/10/2008 instead of prospective on 18/2/2010. And the impugned letter dated 18/11/8/2022 and 19/10/2022 issued by the respondent number 2 to the NPSC against the recommendation of the petitioner for appointment as postgraduate teachers after declaration of the NPSC result. Pursuant to the filing of the instant petition, affidavit in opposition has been filed by the respondent numbers 1, 2, and 3. Wherein it is the specific case of the said respondents that there was no relaxation given in respect of other subjects other than maths and physics in the requisition form as regards the qualification of B.Ed. Under such circumstances, the respondent in the respondent Nagaland's Public Service Commission could not have made the recommendation in respect to the appellants. The requisitions which were made have been enclosed to the said affidavit in opposition. This court also finds it relevant to take note of the affidavit in opposition filed by the respondent number by the Nagaland Public Service Commission. Where is that? Very good. Public Service Commission. Wherein it has been mentioned that the Secretary, Nagaland Public Service Commission, had written a letter dated 15/11/2022 to the Commissioner and Secretary to the Government of Nagaland PNR Department stating that a notification dated 27/10/2008 with regard to relaxation for undergoing B.Ed course was specified only for pre-primary, primary and graduate teachers, and as such the relaxation for undergoing B.Ed course after being appointed is governed by the notification dated 18/2/2010 for a period of 10 years, which would be effective from the date of passing of the notification dated 18/2/2010 and would lapse on 17/2/2020 in respect to postgraduate teachers. It is under such circumstances the NPS, the Nagaland Public Service Commission, was fully satisfied that the case of the petitioners, the appellants herein, falls under the notification dated 18/2/2010 for appointment to the post for which they had applied and had duly recommended their names to the government for appointment, which was later declined by the state respondents in its letters dated 11/8/2022 and 19/10/2022. Full stop. On the basis of the above pleadings, the learned single judge, by the judgment and order 24/11/2023, dismissed the writ petition, holding inter alia that the decision to grant exemption of B.Ed qualification to the identified category of candidates for a period of 10 years with effect from 27/10/2008 and not to extend the exemption for any period thereafter are policy decisions of the government. It was observed that there was no materials to decipher that undue hardship is likely to be caused to any person or class of persons, and public interest would suffer if such exemption from B.Ed qualification is not granted. Therefore, it was the opinion of the learned single judge not to embark on the journey to examine as to why the government took the policy decision to limit the period of 10 years in retrospective manner. The justification as per the learned single judge given by the state respondents not to act upon the recommendation made by the commission in favor of the three petitioners for the post of the PGT (Computer Science), PGT English and PGT Commerce while the communication dated 18/7/2022 was found completely justified as the recommendations were made in deviation of the essential academic qualifications for those posts laid down in the rules of 2017. On the basis thereof, the learned single judge dismissed the writ petitions. This court, next. We have heard the learned counsel appearing on behalf of the appellants, Ms. So-and-so, and the learned AG, Ms. So-and-so, represents the respondent numbers 1, 2, and 3. None has appeared on behalf of the Nagaland Public Service Commission in spite of receipt of notice. In the previous segments of the instant judgment, the argument, the submissions which have been made by the learned counsel appearing on behalf of the appellants and the learned AG appearing on behalf of the state respondents have been duly given an anxious consideration and noted. In the previous segments of the instant judgment, this court had duly taken note of the Nagaland school education, duly taken note of the relevant provisions of the rules of 2017. In the same rule, more particularly rule number 5, it has been categorically mentioned as to what are the requisite qualifications necessary for the purpose of direct recruitment and by promotion. The requisite qualifications necessary has been enumerated in Schedule 2 of the rules of 2017. In the same rule, in Schedule 2, this court had quoted serial number 8 of Schedule 2, serial number 8, had quoted serial number 8 in respect to higher secondary cadre stipulated in Schedule 2, which categorically specify as to what are the essential qualifications required for the purpose of appointment, for the purpose of recruitment, either by direct recruitment or recruitment from the lower cadres. From the same column number 8, as quoted above, it would be seen that the Bachelor of Education, the qualification of Bachelor of Education from any National Council of Teacher Education recognized institution is one of the essential conditions. This court have also taken note of Rule 32 of the rules of 2017, which stipulates that the governor, which empowers the governor to relax the application of a particular rule in respect to any person if there is an undue hardship likely to be caused by the application of any of the rules, and that too for good and sufficient reasons, which shall be without prejudice to the interest of any other member of the service. The said rule further makes it clear that this relaxation has to be subsequent and has to be in respect of a person, any person, and has to be subsequent to the coming into effect of the rules of 2017. In the instant case, the requisition which was made by the government of Nagaland specifically stipulated that the advertisement would be carried out in terms with the rules of 2017. Under such circumstances, neither the office memorandum dated 18/2/2010 nor any other office memorandum prior to the rules of 2017 could have permitted the relaxation of the rules, relaxation of the educational qualifications after the coming into effect of the service rules of the rules of 2017. In that view of the matter, we are of an unhesitant opinion that the question of relaxation being given by the Nagaland Public Service Commission in respect to the appellants herein of making a recommendation that too when the appellant does not possess the B.Ed degree is not in accordance with the rules of 2017. Consequently, the decision of the state government to reject the recommendation by the impugned letters dated 1811, impugned letters dated 18 impugned letters dated 18/11/2022 and 19/10/2022 cannot be said to be illegal and requiring an interpretation, any interference. Consequently, we find therefore no merit in the instant appeal, for which the instant appeal stands dismissed. However, in the peculiar facts of the case, we are not inclined to impose any cost.
Our Poco DB0 That's why I said. Okay, okay, I'll visit.
Please, Lordship.
Hmm.
Lordship, I beg to mention hearing item number 20. Lordship, here this matter is wrongly listed, Lordship. It was supposed to be listed on Thursday.
20.
Item number 20, hearing item 20.
Hmm.
On the previous occasion, with the consent of all the parties, the matter was fixed on Thursday.
Okay.
Since the government advocate said it won't be available on Thursday. So if this matter may be fixed on Thursday, Lordship.
Item number 20 to be listed on Thursday.
Obliged, Lordship.
Sorry, Mr. I'd like to mention item number 1.
Yes.
I have received the affidavit in reply just this morning. So I will be given a week's time to go through the
You have filed a reply.
reply by the.
Let's take the item number 1 first, then we'll see what is to be done. Yes. Let's take it.
For admission, item number 1.
This is the item like this.
You have filed a reply. What is the matter about?
Your Lordship, this is about the Rangabahar military station.
Hmm.
So Rangabahar military station has been established on land which belongs to Tahaka village. And there has been no acquisition process till date.
They have?
There has been no acquisition process still date.
What is the stand of the union?
Then it is up to the state. The stand of the union is that it is up to the state. It is for the state to answer. The state has recommended through a body which is known as the State Land Acquisition Authority, which is not a body in terms of the Acquisition Act. The state has recommended to the union that compensation be paid for the Rangapur military station, but not to me, the landowner, but to another party who is a stranger as far as I'm concerned. That is the case, ma'am.
And for that, Mr. Iralu is.
Yes, ma'am. My only issue may seek your lordship's indulgence. If your lordship is going to allow the prayer for adjournment for a week, lordship, in the first week of March, I have many matters fixed. Then second and third week of March, I have to go out of station for my children's educational purposes. If it can be fixed on 26th of March. 26th of March. That's a Tuesday. Monday is a holiday.
That's only 2 days in that week, 26th and 27th.
You can try my.
We'll have it in the first week of April.
Very well. Very well.
Let's admit the matter.
Yes, ma'am.
Upon hearing the learned counsels appearing on behalf of the parties and taking into account that the pleadings are complete, the writ petition is admitted, issue rule, taking into account that the parties have duly received their copies of the writ petition as well as the pleadings, there is no further necessity of serving additional copies of the pleadings. List the matter for hearing on 2nd of April 2024.
Much obliged.
1 and 2, na?
1 and 2.
For admission, item number 3.
This is Lordship. Lordship, I'm standing on behalf of my senior counsel. Our affidavit is ready, but we have sent to obtain signature from the client, so kindly grant us 1 week time.
The learned counsel appearing on behalf of the petitioner submits that the affidavit in opposition,
Affidavit in reply.
affidavit in reply to the affidavit in opposition would be filed during the course of the day.
1 week time, Lordship,
What week, 1 week time, then it is
because
subject
the
to cost.
petitioners are from
The affidavit
different
was
districts.
filed on 24/3/2023.
Yes, Lordship.
We are almost 1 year. So costs
No,
55,000.
Lordship, my apologies.
55,000. Who is appearing for the state? Lucky they are not there. So we will construe that the state has waived the cost. Okay. The learned counsel appearing on behalf of the petitioner submits that the affidavit to be in reply to the affidavit in opposition filed by the respondent state is ready and would be filed within a week. This is the matter again on 11th of March 2024. The affidavit in reply be filed without fail by 4th of March 2023.
Lordship, like,
For admission, item number 4.
Yes.
Here the state is yet to file.
Regularization of the petitioner.
Yes, ma'am. As per OM dated 17/3/2015.
You are retired.
Yes, madam.
Have you retired?
Yes, madam. I'm ready.
This was filed when you were 55 years old. How did you retire?
On completion of 35 years in service.
You completed 35 years.
Yes, madam.
And what is the stand of the government? That you were not having the scale of pay.
No, my lord, I'm enjoying scale of pay, and then my case has been forwarded to the government way back in the year 2018, August 2018. However, until my retirement, the state respondent has not considered my case, and that's why I'm before this honor. My lord, Annex D is the forwarding letter for my regularization forwarded by the respondent number 3, my lord. And my name is listed at serial number 2, page 22, my lord. Page 22 of the writ petition, my lord.
Name of the petitioner?
Rangsumung Sangtam, my lord. Serial number 2.
Rangsumung Sangtam.
Yes, my lord.
Date of appointment, date of retirement.
I'm retired on 30/11/2021, my lord.
Yes, government. Why he may not be given regularization, but the question is, why not his pensionary benefits?
Your Lordship, I have filed an affidavit, Your
I've
Lordship.
seen it.
Yes, Your Lordship.
But then why he should not be given the pensionary benefits? Because he was, or he ought to have been regularized.
Yes,
Because he
Your
has completed 30 years of
Yes,
service as per 17(3).
Yes, Your
So
Lordship.
you have not done that. And under such circumstances, it is on the account of your laxity this has happened.
Yes, Your Lordship.
Because
Actually,
if I see more particularly 17(9)2015 and clause 1 Roman 2, it stipulates that if a person did not complete the period with as on 1/1/2015, 30 years, thereafter you have to take into consideration all cases who completes 30 years in the month of January or July.
Yes, Your Lordship.
You have not considered the case of the petitioner.
Yes, Your Lordship.
So under such circumstances, after working for 30 years, taking their service for 30 years, can you say that he is not entitled to pensionary benefits? Yes, he may not be, forget about the regularization now. But the question is, how can you ask him not to get a pensionary benefits? In view of that judgment, where is the judgment? Justice M.R. Shah, wherein it says that a person who have worked for 30 years, after taking their service for 30 years, you cannot just say that, oh, we are not going to do that. Where is it?
Yes, ma'am.
What
I'll get it,
is?
ma'am.
You have to produce the judgment. Where are you going?
My lord, it's at the back.
Okay, you have it?
One of it, mine.
Yes, madam.
Your Lordship, I have stated in my affidavit that we admitted to the fact that the petitioner was at serial number 2, Your Lordship. However, meantime, Your Lordship, there was a verification. All the work charge, those employees who are appointed under work charge was under verification, Your Lordship. And that verification, it is not only relating to one department, Your Lordship, so it consists of every department. So it took time, and that is why we could not able to consider. Otherwise, Your Lordship, definitely we admit to the position that he's under
No,
zone
he
of
may not be
consideration.
entitled to regularization, but he has to be granted the pension. There is one judgment, I forgot the name of the judgment there.
My lord, which I have with me now is the state of Gujarat and others versus Dalsipai. That one I have, my lord, and Prem Singh. Prem Singh.
No. State of Gujarat
Yes, state of Gujarat
versus.
versus Dalsipai.
I mean, that's a one-page order.
Short order. ma'am. It's an order. Like.
Not this one. Another one very nicely given.
And my lord, one more judgment I have. There is state of Manipur and other versus cases Dibobal in my lord.
For me? Yes, what has been?
State of Manipur na other versus KSH Ipo Wal Singh Malo.
Keep that.
GLD 2009-1997, Volume 2, my lord.
What does he say?
My lord, relevant at para 11 and 12, my lord. May I read, my lord?
Wait, not that one. The Supreme Court judgment makes it very clear. I was actually taking up the pension bench in Gauhati. I think that was sometime in the month of February 2023. Pratap Thakur. You see, the judgment which I am referring to is a judgment which came up before the state of Bihar. Here, in this case, these people were workers, employees. They were not working in a substantive post. The question arose out there as to whether they would be entitled to pension or that period of service could have been taken for qualifying service because you give it on the basis of qualifying service. The Supreme Court says that out here, this particular paragraph, more particularly here, insofar as the submission on behalf of the appellants that the entire service rendered as a work charge should be considered and or counted for the purpose of pension, quantum of pension is concerned, the same cannot be accepted. If the same is accepted, in that case, it would tantamount to regularizing their services from the initial appointment as a work charge. As per the catena of decisions of this court, there is always a difference and distinction between a regular employee appointed on a substantive post and a work charge employee working under the work charge establishment. The work charge employees are not appointed on a substantive post. They are not appointed after due process of selection and as per the recruitment rules. Therefore, the service rendered as a work charge cannot be counted for the purpose of pension or quantum of pension. However, at the same time, after rendering of service as a work charge for a number of years and thereafter, when the services have been regularized, they cannot be denied the pension on the ground that they have not completed the qualifying service for pension. That is why the service rendered as work charge is to be counted and or considered for the purpose of qualifying service for pension which is provided under so and so. Insofar as the reliance placed upon the decision of the court in the case of Prem Singh, but learned counsel appearing here, the reliance placed under the said decision is absolutely misplaced. In that case, this court was considering the validity of Rule 3.8 of the UP retirement benefit rules under which the entire service rendered as work charge was not to be counted for qualifying service for pension. To this court had observed and held that after rendering service as work charge for a number of years in the government establishment, denying them the pension on the ground that they have not completed the qualifying service for pension would be unjust and arbitrary. Therefore, this court has observed and held that their services rendered as work charge shall be considered counted for qualifying service. This court had not observed and held that the entire service rendered as work charge should be considered here, in view of the real lacks merit and so and so. Now, this is the judgment in the case of Uday Pratap Thakur. Now, if we apply the same principle out here, here is a case where the petitioner was entitled for regularization in terms with the scheme. On account of some delay which has been committed, in the meantime, the petitioner had retired. But his right of regularization was there, which have not been considered. So under such circumstances, whether you are going to do retrospectively the regularization, that is your concern. But the question is that the petitioner herein would be entitled to, because he meets the criteria in terms with the 17-9-2015. Isn't it?
17.3, man.
17.3. 17.9 is compassionate.
Yes.
Yes.
Your Lordship, the case of the petitioner is covered by this OEM, Your Lordship.
Understood.
Yes,
So, but as of now, you have not regularized.
Yes, Your Lordship, because of the problem like verification of the work charge employees, Your Lordship, because of that process, Your Lordship, all this process was held up, Your Lordship.
Understood, but are you going to regularize him?
Yes, Your Lordship.
And grant
for the
him
purpose
pension?
of pensioner benefits.
No, only for the purpose of
Yes,
pension.
only for
Because
the
normally because your regularization has to go back, date back to the date when he was in service.
Yes, Your Lordship. So only for the purpose of pensioner benefits, Your Lordship.
So is it mentioned in your affidavit?
No,
That for the
I have mentioned that like the case of the petition will be considered, Your Lordship, as and when the government appraised the status of the verification report, Your Lordship.
And as such, the department can only consider the case only after following the above
That-
mentioned late procedure.
That is the procedure, like after Your Lordship, a decision is taken to consider the case, there is a procedure, Your Lordship. It is laid down in the OEM, Your Lordship.
But when you are required to do in terms of clause 3.2 or 3.3,
Yes, sir.
where is that office memorandum?
Page 17, Your Lordship.
Of the reputation. Yes. We come to 1.3. 1.2, in respect of those work charge employees, because as on 2015, did he complete 30 years? Did he complete 30 years as on 1/3/2015?
Yes, madam.
Huh?
As on 1/1/2015, madam.
Yes, did you
Yes.
complete 30 years?
No, by the time.
When did you complete 30 years? 30 years you joined out there on date of appointment is
2016, my lord.
86. 30 years will be 2016.
Yes, madam.
So as on date, so you will come within the ambit of 1.2. 1 Roman 2, didn't it, madam? Page 18.
Yes, Your Lordship.
He will come. So his case what's to be considered on batches of 1st of
Batches.
July or the year of that year,
Yes, Your Lordship.
of every year,
Yes, Your Lordship.
which have however not happened from 2016 till 2024.
Yes, Your Lordship. Because of that procedure, as I have
Whatever
stated,
may be.
because of that
So
verification.
it has been on the account of the laxity on the part, because this thing has come all along earlier. But
Yeah, Your Lordship,
once he is regularized, it will be only as regards his qualifying service will be only the minimum. Or are you going to count from that initial point?
Your Lordship, usually in this kind of case, we only regularize for the purpose of pension, Your Lordship.
But pension, how do you work out the
It will
pension?
be, I think from the entry point.
It can't be from the entry point. Are you regularizing from the date of his appointment and when there is no post? It will have far-reaching consequences.
Yes, Your Lordship.
My lord, ask where the practice of the, it's from the date of regularization, madam.
No, not from the date of the regularization also you do not have. You see, to get a pension, you need a qualifying service. The qualifying service is 10 years.
Yes.
The qualifying service has to be taken from the date. So therefore, what has to be given, once is regularized, then it has to go back to have the minimum qualifying service for the, so that you get the pension. Because all pensions are worked out on the basis of qualifying service. A person who has rendered initial appointment with 30 years would get a higher pension than a person who is retired, who gets less. Isn't it?
My lord, as per my understanding, the scheme, from the day I completed 30 years of age.
Then you have only 5
years.
years, you won't get
Yes.
pension. You'll be only given service gratuity. You see, as per them, the CCS pension rules applies.
Yes,
What is the requirement of qualifying service?
10 years. as per
10
CCS,
years.
yes.
So you'll have to go that from the date when she is appointed as a qualified regular employee or regularization, that has to be taking into account that the minimum qualifying service to be. If you don't have that, you won't get the benefit of pension.
Your Lordship, if you can kindly come to 1F, Your Lordship, of the OM.
Yes.
The past service rendered as work charge casual employees shall be counted towards length of service for the purpose of Nagaland Retirement from Public Employment Act 2009 and as qualifying service for the purpose of pension.
So that is the minimum.
Yes, Your Lordship.
So we dispose it of,
Yes, Lordship.
directing you
Yes, Your Lordship.
to regularize as per this,
Yes, Your Lordship.
which you are doing it,
Yes, Your Lordship.
and so that he gets the pension, because after all, a person who has retired in 2001 cannot survive without a pension.
Your Lordship,
Where will he go?
yes, Your Lordship, while considering the case of the petitioner, Your Lordship, considerable time may be given to an.
What considerable time?
Your
Then you
Lordship, at
pay
least-
interest,
Your Lordship, at least 6 months, Your Lordship, because.
pay interest.
Your Lordship, there's a procedure because.
The procedure started long time back. He
Your Lordship,
qualified in
it was-
2016.
Your Lordship, as I have stated, is what put on hold, Your Lordship, because of the.
Understood, but then also he will be entitled from that point. The area pension will be there.
Your Lordship, sometime, Your Lordship, I will need to.
No, there has to be area pension, because you cannot say tomorrow, what will he do? On one hand, if you don't, yesterday, in fact, the matter came up before the Supreme Court. The district judges are being given a pension of 19,000-20,000. The Supreme Court said, how will a person survive?
Your Lordship, then I'll leave it to your wisdom, Your Lordship.
Fantastic. Okay. The instant heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. So-and-so appearing on behalf of the respondents. The case of the petitioner herein is that the petitioner was appointed by an order bearing number TSG/E/CD/E Roman 1 capital APT-12 dated 24/10/1986 as work charge Khalasi in the scale of pay of rupees 375 is equals to -7 -445 -9 -490 -10 -590 per month under the establishment of the subdivisional office, Public Works Department, Lokhim, Twansang, Central Division, Twansang. Full stop. The petitioner thereupon, by an order dated 17/5/1991, was promoted to the post of WC, sectional assistant, under the same establishment with the scale of pay plus other allowances as admissible in the government of Nagaland from time to time. Full stop. The state government of Nagaland had issued an office memorandum on 17/3/2015, thereby bringing out a scheme for regularization and absorption of work charge and casual employees and revision of pay/wages. Clause 1, Roman 1, relates to those work charge and casual employees of various departments who were enjoying scale of pay and who had completed 30 years or more service as on 1/1/2015, who would be regularized by conversion of their post into personal ones, personal to them, and subject to fulfillment of the conditions as indicated therein. Relevant herein to take note of clause 1, Roman 1, bracket F, which stipulates that the past service rendered as work charge casual employee would be counted towards the length of service for the purpose of Nagaland Retirement from Public Employment Act 2009 and as qualifying service for the purpose of pension. Clause 1, Roman 2 relates to those work charge and casual employees in the scale of pay, in scale pay, who have completed or would complete 30 years of continuous service after 1/1/2015, and their case for regularization would be taken up subsequently in 2 batches as on 1st of July and 1st of January every year. The said clause further stipulates that once the period of 30 years of continuous service is completed after 1/1/2015, the procedure as stipulated in the said office memorandum shall be laid applied. First, in the instant case, the petitioner herein completed the 30 years on
24 October, madam. 24 October.
1/11/2016. 2016.
Yes, ma'am.
Full stop. However, the case of the petitioner for regularization in terms with the office memorandum dated 17/3/2015 have not yet been 17/3, na? 17/3 have not yet been decided by the respondent authorities. Although, in terms with clause 1 Roman 2 of the office memorandum, the petitioner's case ought to have been considered in the month of January or July of that year. Be that as it may, as in terms with the Nagaland Employment Days Act, 35 years. What is that? A person completes 35 years or ages this. What is that?
Nagaland Retirement from Public
Huh?
Employment Act.
Be that as it may, in view of the provisions of section
Section Your Lordship, that's not.
provisions of the Nagaland
Nagaland Retirement from Public Employment, Your Lordship.
Act so and
Act
so.
2009.
The petitioner, upon completion of 35 years, had retired on 30/11/2021.
Yes.
Full stop. Taking into account that the petitioner's case for regularization was not taken up by the respondent authorities, which was contrary to the office memorandum dated 17/3/2015, and consequently the petitioner have not been paid his pension, the petitioner has approached this court under Article 226 of the Constitution by filing the instant writ petition on 27/7/2022. The record reveals that this court, by an order dated 29/7/2022, issued notice and also making an observation that the pendency of the writ petition shall not bar the respondent authorities to consider the case of the petitioner for regularization of his service. The record reveals that an affidavit in opposition has been filed by the respondent numbers 1 to 5. In the said affidavit in opposition, it has been mentioned that the respondent authority is required to carry out various verification process. It has also been mentioned that the case of the petitioner cannot be considered delayed because the Nagaland work charge employees verification is still under process, and due to which all cases of regularization for 30 years and above, the state government has kept it in abeyance till the verification report was scrutinized and finalized. It was further mentioned in another meeting convened on 24/6/2022 by the Secretary Works and Housing, along with the officials of the Works and Housing Department, Engineer-in-Chief, NPWD, and others. It was resolved to review the verification exercise of the work charge employees under the NPWD. It was categorically stated in the said affidavit that the case of the petitioner would be considered taken up as and when the state government apprises the status of verification process of the work charge employees to the departmental concern. It was also mentioned that the Office of the Engineer-in-Chief, Nagaland, Kohima, by the letter dated 18/1/2023, wrote to the Commissioner and Secretary, Works and Housing, to look into the matter as the case of the petitioner along with others. Second phase, after making necessary verification, has been forwarded to the government for regularization. In the backdrop of the above pleadings, this court have also heard the learned counsels appearing on behalf of the petitioner as well as the respondent. The counsel of the petitioner have referred to the judgment of the Supreme Court in the case of the state of Gujarat and others versus Dhanjibhai Patel, rendered by the Supreme Court in civil appeal number in special leave to appeal (C) number 1109/2022, wherein the Supreme Court had observed that the state having continued to take the service of the respondent therein on an ad hoc basis for 30 years, thereafter cannot contend that as the service rendered by the respondents were ad hoc, he would not be entitled to pensionary benefits. The Supreme Court further observed that the High Court was justified in directing the state to pay the pensionary benefits to the respondent therein who had retired after rendering for more than 30 years. This court, having given an anxious consideration and having taken into account the office memorandum dated 17/3/2015, is of the opinion that on the basis of the materials before this court, it is apparent that the petitioner herein had completed 30 years of service as on 30/10/2016.
My lord, as per appointment, or it should be 24/7.
Why? Your date of appointment is given as 1186. Kindly come to page 22.
But as per appointment order, my lord, it's on 17 May, 24 October.
But here it is given. Anyways, let us not go make it complicated. As on completed 30 years of service as on 23/10.
No, 24, my lord. As per the appointment order.
When will you complete 30 years?
30
What is
years.
your age? Tell me.
That is 20.
No,
yes.
Mr. Counsel, you
Yes,
tell me
yes.
your age.
Yes, 20.
20. You were born on some 1990. When are you going to complete your this 30 years of age or the 34
Yes,
years
madam.
of age? You will complete on 31st of
Yes,
December
madam. Yes,
tonight,
madam.
isn't
At that
it?
point, yes.
Then
Yes.
had completed 30 years of service on 23/10/2016. Therefore, the case of the petitioner ought to have been taken into consideration in terms with the office memorandum dated 17/3/2015 for regularization in the month of July or in the month of January the next year, or July 2016, or in the month of January 2017. On account of the delay on the part of the respondent authorities due to certain verification process being initiated in respect to various work charge employees, the respondents did not regularize the services of the petitioner till the petitioner retired from service on 30/11/2021. Upon completion of 35 years of service. Under such circumstances, the delay in consideration of the case of the petitioner for regularization has to be taken as a delay caused by the respondent authorities, thereby depriving the petitioner of his rights in terms with the office memorandum dated 17/3/2015. Considering the above, this court is also of the opinion that the petitioner's case requires to be taken up for regularization at the earliest, and thereupon his pension and pensionary benefits have to be worked out in terms with the Nagaland Retirement from Public Employment Act 2009. Isn't it?
Yes.
No, the pension is done under what provision?
Under this provision only.
There's a pension in this provision.
Yes, it comes under this only.
This Nagaland Retirement for Public Employment says about pension, not under the CCS.
No, Your Lordship.
Accordingly, this court therefore disposes of this petition, directing the respondent authorities, more particularly the respondent numbers, directing the respondent authorities to forthwith take appropriate steps for regularization of the case of the petitioner only for the purpose of pensionary benefits, and thereupon fix the pension as per the extant law. The same exercise be completed within a period of 4 months from the date a certified copy of the instant order is served upon the respondent number 3.
Your Lordship.
Let us give it to the chief engineer.
Chief Engineer, Your Lordship.
Respondent number 3.
Yeah, respondent number 3.
3. With the above observations and directions, the petition stands disposed.
Much obliged, Your Lordship.
For admission, item number 5.
Yes.
Lordship, just a short matter. That is, the petitioner is a retired major from Indian Army, Lordship. Here, the petitioner is challenging the appointment of the respondent number 4 and 5. That is at page 20.
Yes. On the recommendation of the selection board and Iman, it please to appoint the following persons in the vacant of the Iman. Captain so and so. Who is 4 and 5?
Lordship. Respondent number, here serial number 2 is the respondent number 4. And serial number 5 is
Serial number 4.
3, Lordship.
3 is
Three
respondent
is-
number 5.
3 is respondent number 5. So I'm challenging this order, Lordship.
On these are promotional order or what?
No, this is just an appointment order
Direct
of
recruit.
ex-army re-employment.
Hmm.
Now what has happened is Lordship will kindly come to advertisement, that is page, next year be page 8. The advertisement of the post.
Hmm.
The +1 gazetted, Lordship,
Hmm.
serial number.
We are in respect to which post?
We are, I am in respect of Deputy Director, Zilla Sainik Board, serial number 2.
Where is that impugn order page? Got it. Annexure E, na?
Annexure B,
We
Lordship.
are concerned with deputy director, na?
Deputy Director, Lordship.
Deputy director,
Now,
Zilla Sainik. Level 15, colonel, lieutenant colonel or major. In case non-availability of retired officer mentioned above, captain may be appointed. So captain will come only if you don't have a colonel, lieutenant colonel or major.
Lordship,
Then,
I will just focus on the advertisement. Advertisement, Lordship, eligible criteria is there.
yes.
How to apply? I'm on this, Lordship. 6. Simple application in plain paper with following details. Documents may be submitted to the registered post to the undersigned by name so as to reach by 4 p.m. on 21/3/2020. This is the closing date, Lordship. Application by hand will not
Be accepted.
be accepted. Inquiry regarding result of application will not be entertained, and canvassing in any form will disqualify for impanelment. Now what has happened is, Lordship, respondent number 5, application is
By hand?
on the face of record at annexure G, page 23.
Then,
He applied on 25th November 2021. This is my case, Lordship.
oh, after a long time.
Yes, that is exactly, and he was selected. That is one aspect.
Then,
And after more than a year, Lordship, he applied. The second application is in December 2021, 4th December 2021. He applied twice.
who?
This respondent number 5. It is in their affidavit in opposition. He applied twice, even after, this is in November, and on December 4th, he again applied. This is the way of conducting this impanelment, Lordship. Now, again, in violation of the advertisement, his application by hand will not be accepted. This also he submitted by hand, and within 1 or 2 days, his name was impaneled, Lordship. So that is
So your case is simple to that,
yes,
not a complicated case.
not complicated, just simple as
Although the
that.
file is bigger.
Then, in respect of respondent number 4, he was appointed in violation of Rule 2C, Roman 2.
2C,
Yes, Lordship. It is annexed in the government affidavit, Lordship,
who has
affidavit.
been released from service or on a service after completing the specific period of engagement, otherwise then at his own request or by way of dismissal, discharge, or an account of misconduct or inefficiency, has been given a gratuity and includes personnel of territory army. Yes, here, why is he disqualified?
In respondent number 2 and 3 affidavit in opposition, it's annexed.
Yes, I've seen it. Respond number 1, no.
The rules, amended rules,
Page-
ex-service re-employment in central civil service and post-amendment rules 2012.
Yes, page.
At page
Let us come to page 3 of the affidavit filed by respond number 4 and 5.
the rules, this amendment rules, they have not annexed, Lordship. That's
No,
why
it is there. These amended rules are here. You kindly come to
page 3.
the affidavit of the annexure, respond number 1.
They have not annexed.
Yes, it is there. Notification of 4th of October 2012. These rules shall be called the ex-servicemen redeployment in civil service, central civil service post amendment rules. We got it?
It's,
Chalo.
I beg your pardon, Lordship.
Affidavit of the respond number 1.
Enclosure 1 of the affidavit.
Yes, yes.
Enclosure 1 of the affidavit in opposition of the respondent number 1, Lordship.
Yes. What is your
So-
case?
No.
So as regards the respond number 5, he submitted the application subsequently.
Yes.
What is the allegation against respond number 4?
Fourth October, yes, Lordship. This is 4th October. This one, in respect of the respondent number 4, the ex-army man must be a pensioner,
Huh?
but a pensioner,
Bachelor
pensioner.
or pensioner?
Yes, Lordship. But he is not. In respect of the respondent number 4.
Where is it required that he has to be a pensioner?
If that is the case, even the writ petitioner is not even entitled to file a prison writ petition. He regarded as a short service commission.
What do you say about you are appearing for respond number 5?
4 in 5.
5.
4 in 5.
Oh, 4 is okay. Let us not disturb him. We are only concerned with one post. Tell me how did the respondent number 5
Yes, sir.
apply?
Lordship, the respondent number 5,
Applied when?
Lordship, as per the advertisement, the last date for submission of application was 21st March 2020.
Yes.
Lordship, immediately after this date, the national lockdown started due to the COVID-19 pandemic.
So,
Thereafter, Lordship,
no, there has to be then a corrigendum. Was there any corrigendum issue?
no provision was-
Then
but Lordship,
how can they take into consideration other people?
Lordship, it happened like
Then
this.
there will be many others who could have applied.
Yes, there were many.
Lordship, it was an emergency situation.
So what? There's no emergency. For you, it is emergency. The government has not stated to be emergency.
No, Lordship, the state government didn't attempt to state.
No, but did the government enlarge it by way of a notification? If they have not disposed the selection to petitioner number 5 has to go. Respond number 5. Yes, government.
Lordship,
will
tell me
get
like this. Lordship, just allow me to submit one ground.
Yes.
Lordship, after the state government, after immediately after this COVID-19 pandemic came, they have issued a notification banning all the fresh appointment. Subsequently, they have relaxed that. Thereafter, the recruitment for this very has been started. Accordingly, I've submitted.
No, Mr. Kindly appreciate. Was there any notification issued enlarging the period?
No, Lordship.
Then-
But Lordship,
This is the case where it has to be, that has to be struck down.
no, Lordship, this recruitment, it has to be conducted on the basis of a guideline issued by the ministry. As per the guideline issued by the ministry, the state government role is only to submit the list of panel.
Huh?
The state government, they have to prepare a list of panel. That means the list of the applicants. That will be the state government duties to forward the list of panel to the ministry. The ministry will scrutinize and vet the applicant. Thereafter, on the basis of the final approval of panel issued by the ministry, the state government will conduct the interview. Accordingly, I've applied. And my name also included in the panel. In the final panel.
Council, why are we digressing
No,
to
Lordship.
anything else?
The-
No, you tell me only one thing.
Lordship, yes.
Is it required for appointment to the post on the basis of an advertisement?
Lordship, the writ petitioner.
No,
Lordship,
forget about the writ petitioner. Let us not go into
No,
it.
Lordship,
I am only telling you whether there is a requirement of an advertisement.
very much. Lordship.
Now, tomorrow, if they extend the period, there might be other people who could have been taken.
Other people, they were also allowed to participate in the selection process.
Now, how will they know?
No, Lordship, the respondent number 5, along with one of.
Anyways, let us hear the government. Yes, who is paying for the state, the central government? The state government. Yes, what do you have to say? How could you have done that, allowed the respondent number 5 to participate without a corrigendum to the advertisement?
One of these forest state respondent, as per the panel provided by the state respondent, we have scrutinized and approved the names of.
No, you are the central government.
Yes, ma'am.
Appointment has to be made under you, by you. Who
State
appoints?
government, madam.
State government. Yes, madam, state government, you are there. How could you have allowed this?
Lordship, so, Your Lordship, the advertisement was published on 12 February 2020. And after the advertisement, Your Lordship, COVID, because of the COVID
Understood,
situation.
but did
yes.
you issue a corrigendum?
Because of the everything has been locked down, Your Lordship, and
So-
because of the peculiar conditions, like we could not go ahead with the
So only those
advertisement.
people who knew
Yes.
could have participated.
So, Your Lordship, in
So
my
you
affidavit,
you are therefore ought to have cancelled the entire advertisement.
yes,
Then-
but we have not done that. But Your
Then
Lordship,
We set aside this.
in the meantime, we have received so many applicants, Your Lordship. I have also categorically stated.
How
in
many?
We have a number we have not given, but Your Lordship, in the meantime, we have received many applicants. So all those applicants' name along
But
with
how
the
could you do
petitioner,
so?
we have forwarded to
Wasn't
the-
it, madam, wasn't it contrary to your advertisement?
Yes, but
Then-
Your Lordship, we have forwarded to the Kendriya signing board.
So
So
what?
the board has
Those appointment has to be set
approved.
aside.
So only after the approval, we call for interview, Your Lordship.
We have not touching on 4, but 5 has to be touched.
Lordship, before hearing, my lord will kindly come to page 6, annexure 1 of the affidavit in reply. I have annexed a new document here. This was
Affidavit in-
procured from other source. Affidavit for respondent number 2 and 3. I have annexed in all the affidavit in reply to the affidavit in oppositions.
Yes.
My lord, page 6, annexure 1.
Affidavit in reply to the affidavit in opposition of respondent number 4 and 5? Or
2 and 3, 2 and 3.
Yes. Yes, tell me.
This is a letter sent to the
Page,
page 6, page 6. Annexure 1.
Yes.
This was sent to the state respondents.
Ah.
This is 7th December 2021. Respected sir, I am sending this mail for kind consideration and necessary action, please. As per your guideline published on daily newspaper so and so, dated 25th November 2021. A. Any application submitted after 4 p.m. on 21 March 2020 should not be accepted as per the guide issued by your kind office.
This
Two.
is written by whom?
This is written by KSB, Kendriya Sainik Board.
From Sarat Kapoor, DGR at JSB. So this is being written.
Yes, Lordship.
Then also they have done it. No, it's item. We said aside this. Rest is for the division bench to consider.
Kendriya Sainik Board, Lordship.
We can set aside only as regards respond number 5.
Yes, Lordship.
It's not
Yes.
respondent number 5. Lordship, kindly allow me 5 minutes.
5.
5 minutes.
5. Respond number 5 we said.
Then B is also, as per the advertisement, B is also there. Any application submitted by hand or through other channel other than the registered post addressed to the undersigned.
No, we are not, madam, we are not concerned with other
Yes.
things. The matter is simple. The advertisement stated this.
Exactly,
There
Lordship.
is a violation of not only the
Exactly.
case of the petitioner, of all other people who are eligible. How could you have accepted without the collision matter?
Exactly, Lordship.
Lordship, in that case, Lordship, are you allowed to rely only one judgment person? This is the case which was from the state of Assam. In respect of the recruitment of sub-inspector of police.
Huh?
That is the case. Lordship, here also this is a case where the state respondent have conducted the interview in violation of the terms and conditions prescribed in the advertisement. There has been a similar case. This is reported in the year 2019 volume 3, but passed by the Supreme Court.
What does he say?
Here it says, Lordship, this is a case which arose from the state of Assam regarding the recruitment of sub-inspector of police. Here also certain guidelines were given in the advertisement. However, the selection committee took a decision in deviated from the procedure. So that issue came up before the Supreme Court. The Supreme Court says that when the appellant hearing, he was well aware about the deviation from the procedure. However, he participated in the selection process. After he participated in the selection process, he is stopped from judging the state selection process. That is the judgment passed by the. He also the same. The list of panel was approved by the ministry. The writ petitioner, he was well aware of the panel, list of panel.
No, we are not concerned with the
No,
panel.
Lordship.
We are not concerned with the panel. We are not concerned with anything else. We are concerned that the advertisement concerned categorically mentioned to
This is a
submit.
case where the.
Then
where the
this is the matter to be argued before the division bench for that. Once I dismiss, allow the
No,
petition.
Lordship, this is a case where the deviate from the procedure prescribed in the advertisement. Lordship, you can-
The instant repetition. The rest is for division bench. The instant repetition has been filed challenging the appointment of the respondent numbers 4 and 5 to the post of the Deputy Director, Jila Sainik Welfare Officer, Kohima, to the post of Deputy Director, and also seeking a direction that the petitioner be appointed as the Deputy Director. From the facts appearing on record, it reveals that an advertisement was issued on 12/2/2020 in respect of various posts enumerated in respect of various class 1 bracket gazetted and class 3 and class 4 non-gazetted. This advertisement was invited from ex-servicemen eligible retired Army, Navy and Air Force commissioned officers and personnel below officers rank bracket P BOR bracket close, so as to reach the undersigned by 21/3/2020 for re-employment against the various posts advertised. In clause 6 of the said advertisement, it was categorically mentioned that a simple application had to be filed in plain paper with various details, and the said application has to be sent by registered post to the Special Secretary to the Government of Nagaland. So as to reach by 4 p.m. on 21/3/2020. Further to that, it was also mentioned that the application by hand will not be accepted, and any inquiry regarding the result of an application would not be entertained, and canvassing in any form would disqualify the empanelment. Pursuant thereto, various persons, including the petitioners, submitted their applications. However, admittedly, the respondent number 5 did not submit the application within 21/3/2020, but submitted the application on
25
25/11/2021
November also on
and subsequently submitted another representation
application lodge, second application
on
4/12/2021.
on 4/12/2021.
4/12/2021, this is not a fresh application. In response
That's
to
why.
first application.
Where's 4/12? Where's the document 4/12?
In my affidavit,
Affidavit in
page 23.
of the, they themselves have annexed.
Submitted an application on first date you give, huh?
4/12/2021. This is a. In the first application, my name was shown in the remarks column. The service code is not submitted. So for rectification, this was submitted.
Where is that 4/12?
Page 23 in my affidavit numbers.
Page
23.
and further followed up with another application on 4/12/2021, making a reference to the initial application filed on 25/11/2021. Stating therein that as the respondent number 5 was found ineligible in the list of applicants for the various posts under the RSB Nagaland, the said application dated 4/12/2021 is being shall be treated as a resubmission of his application along with requisite documents. On the basis of the said selection proceedings, by an order dated, where that order?
Lordship appointment order. Their appointment order is at page 20, annexure E.
dated 21/7/2022. The respondent number 4 and 5 were appointed to the post of Deputy Director for a period of 2 years, extendable to a maximum period of 10 years or till one attains 60 years of age, which was earlier. The petitioner, therefore, being aggrieved, has approached this court by challenging the said order of appointment of the respondent number 4 and 5 by the impugned order dated 21/7/2022, and have further sought for a direction that the petitioner be appointed to the post of the Deputy Director. The record reveals that pursuant to the filing of the writ petition on date of filing.
2922, Lordship, filed on 2922.
Huh?
This petition was filed on 2922.
On 2/9/2022, this court, by an order dated 5/9/2022, issued notice subsequent thereto, by another order dated 13/9/2022, observed that the appointment so made to the respondent shall be subject to the outcome of the writ petition. This court, on the pursuant thereto, the various affidavits have been filed, and pursuant to the filing of the writ petition, the various pleadings have been exchanged between the parties. This court have heard the learned counsels for the parties and had given an anxious consideration. During the course of the hearing, this court had made a specific raised a specific pointed query upon Ms. So-and-so, the learned AAG, as to whether there was any further advertisement or corrigendum issued pursuant to the office advertisement dated
12/2020.
Huh?
12/2/2020.
2020, thereby extending the submission of the application beyond 21/3/2020. The learned AAG, with all fairness, submitted that to her instructions there has been no other corrigendum issued. Under such circumstances, this court, this court fails to understand as to how the respondent authorities could have taken into consideration the respondent number 5's application, which was submitted on
25th November 2021.
25th November 2021. And further, when admittedly the said application was rejected, how the respondent authorities again took the application of the petitioner dated 4/12/2020.
4 till 4, 2020.
22.
That is also as per the notice for interview. If there is
Second application.
What is
4
the date?
4/12/21.
21.
Yes, Lordship.
you should become a fish to give the written.
Full stop. Although the learned counsel appearing on behalf of the respondent number 4 and 5 submits that at the time when the last date for the submission of the application fell, submission of the application at the time when the last date of submission of the application pursuant to the advertisement dated 12/2/2020, there was a COVID pandemic. And under such circumstances, the respondents thought it prudent, in its wisdom, had thought it prudent to accept further applications. And therefore, there was no illegality so committed. But the question arises as to, without issuing a further advertisement or a corrigendum, thereby enlarging the period for submission of the application, could the respondent authorities enlarge the period of submission of the application and take into consideration an application submitted by the respondent number 5 on 15/9/2021? In the opinion of this court, taking into account that the service to be the appointment of in respect to the post relates to public employment, the said actions on the part of the respondent authorities in taking into account the application submitted much after by the respondent number 5, much after 21/3/2020, that too without any further advertisement or corrigendum to the advertisement, amounts to violation of the rights under Article 14 of the Constitution. Accordingly, this court interferes with the appointment order dated, what is the date? Dated 21/7/2022, insofar as the appointment of the respondent number 5. However, this court makes it clear that the appointment made in respect to the respondent number 4 or others in the notification dated 21/7/2022 is not interfered with. Consequently, with the above observations and directions, the instant writ petition stands disposed.
For admission, item number 6.
Yes, who is filing the affidavit? Madam,
Lordship, I have need to receive instruction, Your Lordship, affidavit.
this is matter pertaining to what?
Minimum scale
of the
of pay.
scale of pay. As per the
Lordship,
examiner.
if the petitioner so agrees, Your Lordship, the representation is still lying pending, so presentation can be disposed of.
That day I passed an order where he says that he is entitled to minimum of the scale of pay. Pass similar order as per the Honorable Appellate Court Judgment CAV number Imad. Matter of 2023.
Lordship, then can you grant me 3 weeks, Your Lordship, since she's not willing to dispose of the representation, so I'm not going to dispose of today, Your Lordship.
You don't want the disposal?
Not today, Your Lordship.
Why?
Can you grant me
Let
3
the,
weeks?
yes, let the state
Huh?
come with their country lordship.
Why?
Let them come with their instruction, your lordship.
If I am
Otherwise,
going
if your
to
lordship
pass
is
the
ready to
order in your
dispose, then
favor.
yes, your lordship, it can be disposed of also, yes, but not to representation, your lordship.
Huh?
Not to representation, but
No,
if
no,
it
no,
can be.
nothing. But if I am willing to pass an order in your favor that you are entitled to the minimum scale of pay,
In that case, your lordship, then
also you
it
want
may
an
be disposed of
adjournment.
at this, your lordship.
Your lordship,
Because
your lordship may be gracious to grant 3 weeks, your lordship, because there's similar matters, so many matter pending, your lordship, and
No, it is not a
some
question of
decisions-
pending. You see, that day I passed an order. You were there, na?
Your
Who
lordship,
was
that
there?
is disposing of representation.
No,
There was
no,
one
no,
minimum
no.
scale of
I
pay.
said he is entitled to if he's working, discharging the similar duties and having the similar qualifications. And therefore directed the respondents to consider that aspect of the matter and do it within a period of 6 weeks or 6 months. You were there.
No, I wasn't in that case, my
Okay.
colleague. Yeah.
Madam was there.
Lordship, it was my other colleague in Nangami.
Because here, without the affidavit, it would be difficult to ascertain as to whether there was whether you are discharging the same duties,
Lordship.
didn't it?
Yes, your lordship, but I've also stated in my paragraph that I'm discharging similar duties, your lordship.
You are
Like as of
saying,
regular
you are
employees,
saying,
Lordship.
but she's not saying that.
And my case is also covered, your lordship, on the fundamental principles of equal pay for equal work as per the Jagjit Singh case, your lordship.
Understood. The
Yes.
Jagjit Singh said two things. More particularly, I think paragraph number 61. It stated, yes, they are entitled to minimum scale of pay
Lordship.
as is being given to the regular
Lordship.
employees. But the only thing that whether they are discharging the same
Lordship.
duties,
Yes, lordship.
and the second is as to whether they are having the same qualification.
Lordship, lordship,
These are the two aspects.
lordship.
So earlier, when the matter came up before this court earlier, I have disposed of a petition saying that yes, the government have not filed an affidavit in
Yes,
spite of
yes,
various
Lordship, yes.
opportunities being granted. Under such circumstances, this court is not closing the door of the government, but the government will consider as to whether the petitioner is discharging the same duties and also whether the petitioner has the same qualification to that of a regular grade 4. This is a grade 4?
Yes, 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 lordship.
So under such circumstances, the said period will be done, and if it is so, if it is found out that yes, both are same, then the petitioner would be entitled to the regular scale of pay as minimum of the regular scale of pay. So that is my direction.
Yes,
Madam, you have taken the judgment or yes, she remembers. What do you want?
Lordship, my prayer is if you can kindly grant me 3 weeks, your lordship, or maybe 2 weeks. So that I
in
can-
that case, your lordship,
I can
if
find-
a week may be granted to the,
Your lordship, I have not received an instruction, so at least let me ascertain the
Okay.
documents and all.
it was filed
The record reveals
June
that
only.
we impose a little bit of cost upon the state, then in
Oh,
that
your
case,
lordship.
they have not filed.
Your
huh?
lordship, it was filed in June last
Your
year.
lordship, last time.
How many times you have taken adjournments?
Your lordship, I have not received instructions. So
1, 2, 3, 4, 5, 6, 7.
Your lordship,
7
here,
times.
I have received instruction from the PNAR, your lordship. However, the main respondent, like, I have not received from their end, your lordship. So that is the thing. So another,
We impose the cost upon them.
no, your lordship, so 2 weeks will be granted as a last chance, your lordship. So
No,
that
no, no,
I'll-
no. I am not going to grant this. After taking eight adjournments, subject to cost. You want? Madam, you have come all the way in this cold winter. So
Your lordship will be gracious, your lordship. I mean,
10,000.
like, there is,
the graciousness is
so
10,000.
like,
Okay.
your lordship
10,000.
last chance at least and.
No, no, otherwise
last chance
I
effort.
dismiss it. I dispose of it.
Your lordship,
Madam,
then.
I think we'll dispose it of.
Your lordship,
No, I'll pass that same order.
your lordship, then I'll leave it to your wisdom.
I'll pass that same order which has been passed. You have it, no? Just look into it. We dispose it of saying as to whether they will look into this qualification and as to whether you do it. And thereupon you pass an order. You dispose.
Lordship. Lordship.
Yes, this is another file.
Is it still live?
Yeah.
Live?
Mm.
Joshua, your matter was supposed to be mentioned at 12:30, right?
Yes.
Will this person come on in 2016 or 2010? 2000, originally the person. 5 years, resign, work better job, resign.
Regardless of whether the bill was made by other citizens or the state constellation, state levels. But they move all there. State level solutions. Government will normally do scheme like version and state level solution that. Please. This is wrong.
Yes, I'll pick up that matter.
From the supplementary course list, item number 21, 20 to 40.
Please, your lordship. My lord, for the appreciation of your lordship, I have brought some documents. Lordship, the service book, which is maintained only for the regular employees, the NPS, the pension scheme, which is applicable only for the regular employees, and the MSCP for the 2010 batch they have already received. 2013 batch is also under process, lordship. So I may be allowed to place these documents. If my lord advise, I can file it by way of affidavit also.
No. You see, the question involved out here was the creation of the post at that point of time. Was the creation of post by the government of Nagaland?
Yes.
But was it in respect to a scheme or was it in respect to the general employment?
No, lordship. Scheme related employees. No service book, no NPS, no MSCP. That's only for regular employees of the state, lordship.
No, that is different. They have done it. Where's the government of the additional AG?
Really?
They have done it. They have made a mistake. So does it make it that mistake they have done it? These are the only thing that this government, the government should not take back the benefits which you have accrued upon you. That's all. Nothing more than that.
Your lordship.
You see, many cases you find out here, the government, the officers act on the basis of whatever has been done and they do it. But the fundamental question out here is as to whether you were employed under the government in respect to a scheme or under the government in its general cadre. You were never within the general cadre taking into account that your payment was made by the SSA.
No, Lordship, the only concern which my Lord has raised, which I'm not disputing, is the financial aspect that has not been sanctioned by the state. And only on completion of the scheme, that the state was to take over the expenditure aspect. So to that extent, I'm not disputing, Lordship. And the peculiar circumstance which I have repeatedly mentioned before your Lordship, my Lord is fully aware about the financial position of the state. Now, Lordship, if the state is in requirement of the post, but they have no financial,
You see,
yes, Lordship.
The council, the thing is like this. If you see the SSA or the RMSA notifications, it will be shown out there. It will be an amount which will be paid by the government of India, including all the expenditures in respect to the school, how the civil structures will be made. All these things are to be done by the government of India. So under such circumstances,
Lordship.
any person cannot be appointed by the state government in its general cadre. It has to be on the basis of, the appointment has to be on the basis of a scheme. Only thing is, madam, whatever benefits they have accrued,
Yes.
take it as it is, but don't take back the benefits which they have got. Because what will happen now, if this court dismisses the petitions, the petitioner in the meantime must have got some MSCP.
No, they are not government employees. So MSCP does not apply to them. MSCP applies only to them when they are a regular government.
Understood.
Yes.
Did you give them MSCP?
No.
You have not
No,
till
no.
date given the
No.
MSCP. Okay.
I'll produce the documents, Lordship.
Then as
Then
regards,
it will be on mistake only.
Yes.
Otherwise, they are not
the
entitled
officers
to
must
get.
have committed a
Yes,
mistake.
otherwise they are not entitled to get the MSCP.
No, but as it is a mistake, if
Mm.
they have been granted any thing, don't go for recovery.
Yes.
You may go for readjustment, but
Mm.
don't go for recovery.
No, my Lord,
Then,
in that sense, if I may, my Lord, the post creation is also a mistake.
no.
Post has to be created. There's no quarrel. The post has to be created. Otherwise, how can there be an appointment? But whether the post has been created in the general cadre of the government or is it in the scheme?
No, Lordship.
How
There
will
are
there be
the
an
two
appointment?
the 2 points that has already been distinguished by your Lordship.
Hmm.
Who has created the post? Now, Lordship, it is already proved that as far as the 2010 and 2013 batches are concerned, is a post created by the state. And the other post that has been created after the 2010 and 13 batch, which on your Lordship's advice, I brought the documents, but my Lord has not gone into that point. If not, apart from 2010 and 13 batch, all the advertisements after that has been issued by the Nagaland Education Mission Society, Lordship. And that post creation is under the scheme. Here is a post creation, which is a post creation of the state government, Lordship, by the sanction of the governor itself, Lordship.
Understood. But how can there be a creation of a post if the government doesn't have the money? Tell me.
No, my Lord has understood the peculiar circumstance also about given the financial position of the state.
Whatever may be, if the money has come up from SSA can't give the money in respect of the government post.
And in that aspect,
And
Lordship,
if that is being done, then the state of Nagaland will be liable to return the amount. Do you know the implications?
no, my Lord. Now, if the argument has to go on that line, now, my Lord, it is the state who are responsible. It is not the petitioners. So for the mistake, if it is to be a mistake, Lordship,
No.
if the
you
state has
see-
committed a mistake, should the
No.
petitioners bear the brunt?
Mr. Joshua, kindly appreciate one thing. The state out here in its magnanimous, unless otherwise it was not required to regulate. As of now, they have what they have brought in to you or brought to you within the ambit of the state government is a regularization, which they have done, that too without a scheme.
Lordship, when we were regularly selected under regular selection process, can there be two regularization? Because the mainstreaming has got nothing to do with regularization,
The
Lordship.
regularization is not a source of recruitment. The regularization is bringing, if there was a mistake or some irregularities, I would not say illegalities, there's some irregularities out there, to bring it within the fold of the government. This is being done.
Now, my lord, argument is all the more concluded. However, my lord, by the judgment in order dated 2/9/2017, the seniority of the petitioners who are the direct recruits were protected. We also, our categories also, the 2010 and 13 batch also, we filed 3 writ petitions. And the same petition was disposed of by the order dated 1/11/2017.
But
And our seniority
but-
was to be
but-
protected,
but
Lordship.
Was it the contention of the respondents therein that these people were not within the fold of the government?
No, the state has never taken that stand.
Therefore, the judgment out there cannot be used as a ratio.
And even, Your Lordship, the seniority of 2015 was questioned, set aside by this court, Your Lordship.
Has been set aside.
Yes, yes.
Because it was
Set aside.
prayed to,
Yes.
it was our prayer that it should be questioned set aside because those irregularly selected candidates, their seniority was to be counted from the date of their appointment. That's why our prayer was to question set
So
aside
that
and it was questioned set
seniority based
aside.
on the basis of which you are submitting is no longer there.
Yes.
No long, Your Lordship. The 2010 batch were also part of the 2015 seniority list.
Understood, but the question, therefore, the fundamental question is.
And they have
where
not-
would
yes,
be the-
Lordship.
Whatever orders are passed, that's why I'm not concerned of that. Whether there has been at any point any issue pertaining to that these posts were not the posts in the regular cadre.
Lordship, after filing this writ petition, the state has turned around to say that we are not part of the state cadre. If not,
No, you are now a part of the state cadre now. The state is saying now.
no, my lord, it has to be distinguished in 2 ways, Lordship. Earlier, before this mainstreaming, notification dated 2/9/2022 was issued. In the proceedings before this Honorable Court, not just one proceeding, but multiple proceedings, the state has held the point consistently that the 2010 and 2013 are state cadres, Lordship. Now, it amounts to adopting your own child, Lordship, as I'm repeating myself, my lord.
But that was
Respectfully,
not
my
the
lord.
issue there. The issue there was on the question as to whether those people who was there in 2015 would be entitled to the same pay scale which you are enjoying.
Yes, Lordship. But the language may be appreciated, Lordship, that we are state cadres and our seniority.
Tell me, whatever may
Yes,
be, let
Lordship.
them say that they are state cadres or whatever may be. But the question is whether they could have been a state cadre taking into account the payment came from SSA. It was a special scheme under which you were appointed. Because otherwise, tomorrow I say them to be the state cadre. Just for example, I say, do you know the financial implication the state would have now, taking into account that this court has also held that they are state cadres from all this time? Then where is the money of SSA gone? What will the state of Nagaland do then?
And Lordship, even
And
if,
while returning
Yes,
the
Lordship.
money, the people who are now brought within the fold of the government would not get the money.
no, Lordship, by bearing the expenses for a 2010 and 13 batch, Lordship, by the state exchequer, which they have already decided.
Now,
Now, my lord, there is no additional burden, financial burden upon the state, Lordship, to give us seniority. The only relief that we want before this Honorable Court is to protect our seniority, Lordship. There is no financial burden upon the state exchequer, Lordship.
Mr. Counsel, the moment I say that, the effect would be you'll be entitled to MSCP within 10 years. How do you take care of that situation? Wouldn't that be a financial burden?
No, Lordship, 2010 have already received. 2013 is under process. The finance department has already approved, Lordship.
So there would be a financial burden.
No, my lord, there is no additional financial burden
There
by
would be
giving
a
us the
financial
relief of
burden.
protecting our
The
seniority,
moment
Lordship.
a person gets, what is the MSCP? MSCP is a scheme by which a person who ought to have been promoted within this 10 years period, if he is not being promoted, he will be given the next higher grade.
Yes, Lordship.
So next higher grade is an additional accruement which you have had, those 2010 persons, although they are not in the state cadre.
No, Lordship. My lord may kindly appreciate this point. There has been no change in the pay scale or yearly increment because we are streamlined into the state cadre according to the state, Lordship. It is the same continuity, Lordship. From the day we were appointed, the same is continuing, Lordship. So it's not that the state is going to suffer a financial
State is
loss.
going to suffer because of the MSCP they have to pay. Wouldn't that, madam?
2021,
Yes, of course.
yes, Lordship.
And, Your Lordship, MSCP is only applicable to irregular employees.
No,
So,
therefore,
yes, so by mistake, we could have given to the petitioner. There should be.
Now, at this
Right
point,
now we are
Lordship,
not
that's a
asking
very
for
unfortunate
something.
submission, my lord.
no,
Because
understood,
you
it's a very
know-
unfortunate, but madam, I'm asking you, if I just hold today,
Yes,
that yes, the seniority has to be taken from that day,
yes.
then wouldn't that
And
say that they will be entitled to the MSCP
yes,
from that?
everything, yes. So there will be a financial burden, and
Ah.
then at the same time, Your Lordship, there will be.
And this court saying that will have a great financial implication upon the state. The state would have to return the money.
Exactly.
It
Lordship.
would be illegality or misappropriation by the state of the SSA money.
So the only question is.
Your Lordship, there is also a similar matter by the same batch, Lordship, that is pending before the Honorable Court. The same group, the 2010 and 2013 batch. But there is a total of 2,290 employees covering both the graduate teachers as well as the primary teachers. And the documents which I have placed before Lordship is also inclusive of both the GT as well as the PT. My Lord, by disposing of this writ petition separately, it is also going to have an impact on the other writ petition which is pending before His Honorable Court.
No, it will only have an impact that it will be easier for the next judge to say that a similar matter has already been.
Exactly, Your Lordship. Yes.
And if the next judge out there finds, yes, this judgment is wrong, he can very well refer it to a larger bench.
So, my lord, I may be allowed to place some authorities for your lordship's consideration. I'm not going to read out, lordship,
Yes.
but I may be allowed to place the authorities.
Yes. No, only thing I'm worrying, madam, only thing I'm worried, that those persons in the meantime who have got some benefits,
Yes, yes,
just for example, a person has been given an MSCP.
yes, yes.
If I dismiss the petition, the effect would be you will be taking steps for recovery.
Mm.
You should not, because that is a thing which,
Yes,
because
even the Supreme Court
you may
judgment
very well
is-
readjust
Mm.
in future
Yes.
the scale.
Mm.
The scale may be coming to more than that, but it is not their fault.
Yes, yes, yes.
And under such circumstances, to make a recovery from them
Exactly.
at this stage would have a serious consequence.
Yes, yes. Even there is a Supreme Court judgment that we cannot.
Rafiq
recover.
Masih.
Yes, yes. So we
But
cannot
Rafiq
recover.
Masih is a case of retirement,
Mm.
just post-retirement. But
Mm.
whatever may be, the question involved out here is that you should not make those recovery
Mm.
in respect to the advantage which they have, but you
Or
would be
maybe-
able to readjust.
Mm, mm,
And NPS thing which he is submitting out here, yes, you see, let us see the employment, the appointment, where is it?
His lordship, in the appointment order also NPS is to be deducted.
No, no, we will look into it, don't worry. Where is that order we are challenging? 311, na? Where is that impugn order?
That is at page 394, lordship. And the final seniority list at 395.
No, forget about seniority.
they are
I'm not on the
okay,
seniority
yes,
list,
yes.
I'm not. I'm on the order by which that order was passed, by which you have brought within it.
The order passed by the Solemn Court.
No. By which you are impugning some order.
394.
So 394, lordship. 394, annexure 123.
394. Yes, 394. Now, what will happen as regards the NPS amount?
Yes.
It's under the new pension scheme.
Yes.
Now, they have deposited some new pension scheme. Then how are you taking care of?
Lordship, I think that will remain as it is because they will not be covered. These days, there is no pension scheme. Everything is under the new pension scheme.
Understood.
Yes.
You see, as per the new pension scheme,
Yes.
as far as I know, they are going to deposit, certain amount will be deducted from them, and the state will also pay a particular amount.
Yes.
All these amounts, both the amounts are together, then it will, at the end of the day, when he retires out there, he will be given initially 60% and remaining 40% will be paid subsequently in installment or whatever may be. We are not on that. The question out here that at the time of appointment, they had subscribed to the new pension scheme. Now, what will happen to that money which they had deposited and which had accrued paid by the government in regard to that portion? You are now bringing them within the ambit of the 2013 ambit of the state cadre on 21/4/2022.
Yes.
Now, what will happen to the NPS prior to that?
I think your lordship, that will keep on, that will be remain as it is, your lordship. And even after they become the state cadre also, they will have to contribute.
That they will do.
Yes.
But what will happen to that NPS amount which they had deposited, which the state had deposited, you have deposited? Are you going to take away that benefit?
No, I don't think we will take it. It's their entitlement, so they will get it, your lordship, after they retire. Because it's their own money which they are contributing, so whether in the scheme or whatever, your lordship, the moment they retire, everything will go to them.
Can you file a short affidavit only on that? But no, this has to be taken because you are saying today. You are going to say today. Tomorrow, the government will say, no. We never said that.
Lordship, I can take a telephone instruction right now, and the letter to be received after a while, so that I get the instruction and submit to the.
Okay, you get your instructions.
Yes, regarding
Then I'll ask you to put it by way of an affidavit. No, why I'm saying it, this is required. I'll take it up, don't worry. I'll take it up and I'll dispose it of these matters. But the only thing I'm worrying is what will happen to the earlier NPS? Yes, they have deposited a particular amount and the other side has also deposited. Because this notification does not say anything
Your
about
Lordship,
that.
only in the respect of 2013, NPS is mentioned, but in respect of 2010, there is no NPS mentioned.
All pension scheme, Lordship, there is no
Obviously,
confusion.
2010 they would not mention because this is as per the old pension scheme. Because new pension scheme started. No. It couldn't have been because the new pension scheme
2010.
started
Yes, Lordship.
on 1/1/2004. So
But as
therefore,
far
the
as
old
Nagaland is
pension
concerned,
scheme
Lordship,
does not-
after 2010, the new pension scheme started.
No, it can't be. You see, if you go as per the pension scheme, the new pension scheme and the old pension schemes comes out there earlier. The government, you see, this is being regulated out here by the central government. CCS rules. Madam, you just take that telephonic conversation. I'll dictate the judgment in the court today.
Okay, Your Lordship.
My lord.
And also, no recovery.
Yes.
No recovery of the earlier
Yes.
whatever, but you be able to readjust. Now let us go by the actions.
For admission, item number 7.
On behalf of my colleague. Lordship has been instructed that the affidavit is under preparation. So this matter can come up on.
What is there? You, in that judgment which I have delivered today, in another case, this is this minimum of the scale of pay. You consider the representation in terms with that which I have disposed of today. Another matter. What is there? It is only a delaying something. He is entitled to. Only thing is whether the petitioner is discharging the same duties of a grade 4 employee.
Yes, my lord.
And further to that, the petitioner's qualification is staying to that. Then in that case, the petitioner would be entitled to the minimum scale of pay, which is being given to the regular employee. That's all. You need to verify that, and within a period of 4 or 6 months I have given, it will be done.
Lordship, since I don't have the proof with me and this matter is handled by.
Don't require a brief. We only need the representation. The representation is there. And the earlier lawyer who was there was, she was almost there just before lunch. So we dispose it of. Hey, give it to her. To Kagwi. She will dispose it of. I'm not directing payment. I'm saying that you'll consider the representation as to whether it comes within this or that. And if it is found that it is so, you will be entitled.
For admission, item number 8.
He was there. You were there now on the last occasion when I passed that order on new pension and old pension scheme. That minimum of the scale of pay. Yes. So that order, same order. I'm not directing payment that the representation be considered in line with what I have observed. Yes, what is this case, madam?
Your Lordship, this present petition is relating to premature retirement of the petitioner. Premature retirement of the petitioner.
Compulsory? You were compulsorily retired?
Yes. No, not compulsory, by attaining 35 years of service.
Oh. As per you, you don't come under this Nagaland retirement for public employment.
Yes, Your Lordship.
When did you retire?
The completion of 35 years of service was on 31st/03/2023.
Ah. Then?
But however, at this time, I was only 25 years. I attained the age of service only 25 years.
Why?
I haven't completed 35 years.
No, date of entry was of 1988.
Yes, Your Lordship. However, there was an interruption in between for about 3 months. Your Lordship, you may kindly refer to
Okay,
next
okay.
year-
Then
next
I
year
think
to-
affidavit will be required. Mr. So-and-so, the learned counsel appearing on behalf, Mr. V. Chimomi, learned counsel appearing on behalf of the respondent, submits that the affidavit in respect to the instant case is under preparation and would be
No,
filed.
Lordship, I'm yet to receive instruction.
You can't, this is of 3/10/2023. Is under preparation and would be filed within 4 weeks. List the matter on 1st of
In
April
fact,
2000.
I didn't receive instruction from the respondent.
Okay, then if you have not received the instruction, then we'll take up the matter that in spite of 3 times they have taken adjournment, you have not. Okay. The instant writ petition has been filed, challenging the notification dated 21/12/2022, whereby the Deputy Secretary to the Government of Nagaland Home Department Police
Your Lordship,
Establishment Branch
21/11, it's November.
21/11 had released the petitioner from service on completion of 35 years of service on the basis of section 3(1) and 3(2) of the Nagaland Retirement from Public Employment (Second Amendment Act 2009. It is a specific case of the petitioner that although the petitioner was initially appointed on 1/4/1988,
Yes,
but subsequently there was a gap in service.
yes, Your Lordship.
And under such circumstances, the period of the section 3(1) and 3(2) of the Nagaland Retirement from Public Employment Second Amendment Act 2009 could not have been employed. The learned counsel appeared, the respondent, we go on the doctrine of non-traverse and direct, set aside this.
No, Lordship, on the last occasion, Lordship, if Lordship mechanical, on the last occasion,
This
one
court,
interlocutory application was filed by the petitioner, Lordship, and that was disposed of on 12/2/2024.
maybe, whatever may be, this court, upon filing of the writ petition on 4/9/2023, had issued notice making it returnable by 4 weeks. Thereupon, the matter was listed on 3/10/2023, wherein the learned counsel appearing on behalf of the respondent sought for 3 weeks' time to file the affidavit in opposition. Thereupon, the matter was again listed on 6/11/2023, wherein Mr. V. Jimomi, the learned government advocate, sought for another 3 weeks' time for filing the affidavit in opposition. In spite of that, till date, no affidavit in opposition has been filed. Taking into account the above, this court fixes the matter on 1st of April 2024. A final opportunity is given to the state respondent to file their affidavit on or before 22nd of March 2024. The petitioner thereupon shall be at liberty to file the reply. List accordingly.
Much obliged.
For admission, item number 9.
Your Lordship, the state is yet to file counter. Lordship.
Hmm?
The state is yet to file counter.
You have completed 30 years.
Yes, Your Lordship. I'm squarely covered by the 2015 OM, Your Lordship.
Yes, government.
Lordship, here in this case, Lordship, my colleague, Spoonman likes it, Lordship. And then I've been informed that she's yet to file counter. So, Lordship, may please country.
List the matter again on 22nd of March 2024. The respondents are directed to file the affidavit on or before 23/2024 as to whether the petitioners herein would be entitled to the benefits under the office memorandum dated 17/3/2015, and if so entitled, whether the petitioners' cases have been taken up for consideration. List accordingly.
Obliged, my lord.
For admission, item numbers 14 to 17.
Yes, what are these? I heard these matters or something. Ah, this one. Tell me.
Yeah, this my lord. My lord, here the petitioner was appointed on fixed pay. And after serving for 35 years, he was retired.
After
Serving
35
for
years.
35 years, yes, my lord. And then, my lord, the petitioner is.
You are asking for benefit under this scheme?
No, my lord.
Under what?
I'm relying on CCS pensions.
Rule 2?
Yes, my lord. And as well as the order passed by this honorable court in WPC 96 of 14, 104 14 and 105 14, my lord.
And more particularly on the last occasion, you gave the division bench judgment, no?
Yes, my lord.
Herein, did you apply for regularization?
After my retirement, my lord. After my retirement.
Oh, well, if you don't apply during your thing, would you be entitled to?
My lord, the petitioners herein are the villagers. In their lifetime, they could not.
At the moment, if I relax you, for you, there will be hundreds will come. Don't you think so? The problem which arises, you see, you may say, there, oh yeah, the judge is sitting out there, there's no problem with him, he can pass any order. The moment I pass an order,
Yes.
giving you any benefit that you are a villager, so it has to be, everybody will come up with the same plea.
Yes, my lord, but it's the duty of the employer who has to look after the welfare of the petitioner also, my lord. Why? Because they have employed me and give my salary for 35 years. And they know that I'm leaving the office after serving for 35 years. And by denying the pensioner benefits to me, it's denying the fundamental rights of the petitioners, my lord. All these 35 years, long years, I've been following the instruction, and I've been following the duties and also the instructions given to me by the authority, my lord. And my lord, here, the judgment which I'm relying on the judgment and order passed by this honorable court in WBC 96K of 2014 and 104 of 14 as well as 105 of 2014. But the case of the petitioner has been considered, my lord. And they are enjoying pensionary benefits, my lord.
Where? WBC number?
Page number 18, my lord, of my petition, my lord. Page number 18, annexure E, my lord. Starting from page 18.
What happened? These people were also
Of similarly situated person, my lord. And they have been granted pensioner benefits, my lord, after retirement, my lord.
But to bring yourself within the ambit of 17.3 2015,
No, I don't come under that.
you don't come because you did not get a scale of pay.
Yes, sir.
Now, under what circumstances would you be granted a benefit now? In terms of Rule 2?
Yes, madam.
Now, Rule 2 says about a government servant.
Yes, madam.
Now,
But
can you say yourself to be a government servant, taking into account the definition of government servant used in Rule 2H? And the portion where you are referring to,
Yes,
more
sir.
particularly,
yes,
says a government servant normally would be entitled only if he had been confirmed into the service.
yes, madam.
Now, if you don't come within the ambit of a government servant, then can you come, the question of confirmation does not arise.
My lord, there's an order notified by the government of India, my lord.
Understood, but kindly read it. Let's see, read it.
Yes, ma'am.
Yes, in terms with
One
Rule
moment.
2.
Grant of pensionary benefits to temporary government servants retiring on superannuation invalidations on completion of 25 years, now 10 years. Temporary service 1. In terms of Rule 2 of the CCS Pension Rules 1972, a government servant, including civilian government servant in the defense services appointed substantively to a civil service of post
Civil
in-
service of a post in a pensionable. Now tell me first, you are a fixed pay,
Yes, madam.
so you don't come here.
Yes, madam.
Okay, then
Now, to civil service of post in pensionable establishment is eligible for the grant of pension and death cum retirement gratuity. A government servant who at the time of retirement from service does not hold a lien on a permanent pensionable post is not eligible for pension and death cum retirement gratuity, but is eligible for terminal gratuity under sub-rule 1 of Rule 10 or Sub-Rule 1 of Rule 11 of CCS under bracket TS Rules 1965. The question of grant of pension to government servant for retire after long year of service without being confirmed in any post has been under consideration of the government. It has been decided that a government servant who in his retirement from service on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority after he has rendered temporary service of not less than 25 years now, reduced to 10 years, shall be brought within the purview of CCS Pension Rule 1972. And the question holding a pensionable post in a substantive capacity shall be dispensed with in his case, my lord. This morning, my lord.
so therefore you have to be a government servant. Now, who is a government servant? It has been defined here. Let us see. Government servant means a person.
Such a government servant will be eligible for the grant of superannuation or invalid pension, come retirement gratuity, and family pension in accordance with the provisions of the aforesaid laws.
No, government servant means a person who is a member of a service or holds a civil post under the union, and includes any person on foreign service on whose services are temporarily placed at the disposal of the state government or the local authority, is a member of the service or holds a civil post under the state government and whose services are temporarily placed at the disposal of the central government, is in the service of a local or other authority and whose services are temporarily placed at the disposal of the central government. Now, here is a case where you have been appointed on a fixed pay, not to a pensionable post. That's another aspect. Okay, let it be dispensed with, but you don't become a government servant. How do you become a government servant? This order would only apply to those government servants, and the benefit out there is that you need not take into account that a person who has been working shall be brought within the purview, and the condition of holding a pensionable post in a substantive capacity shall be dispensed with, meaning thereby your confirmation is not required. A person who have been working on a temporary or even on a probation not necessary, but a person who have not yet been confirmed for a period of 10 years also, but he has been working, and then upon he retires out there, then only he will be entitled to as per this rule. How do you fit into it? And how does the judgment in the case of state of Nagaland versus Angrepe Kone would be applicable? Because there is a case where those persons concerned were to be regularized, and they're not being granted a regularization, then also that is the reason why the division bench has stated this. How do you take care of your situation in bringing both of it together? Difficult?
My lord, now come, your lordship. Let me take the lordship to page number 18.
Page number?
18, my lord.
80.
18, 118.
18.
Next year of my week.
Yes.
My lord, is the order passed on 2017-2015, wherein this order 3 bundles of writ petition has been disposed. And here the case of the two petitioner has been considered, my lord. And that is in the case of 104K of 2014 and 105K of 2014, my lord. This in these two writ petition, it has been considered, my lord. I may be allowed to place the orders, my lord.
So this order is no longer in existence, which you are referring to. You see, subsequently, there is some order in the Writ Appeal 31 of 2022, madam,
Yes.
wherein this order passed in WPC, the Writ Appeal number, petition number 104. Oh, this is different. Okay, 104. This is done in 2015. And what is this petition, Writ Appeal 31 of 2022? Which was disposed of.
Oh. Lordship is like this, this bunch of writ petition, this was disposed of, directing the state government to regularize the service, against which we file an appeal before the division bench. In the meantime, your lordship, your judgment as well as Justice Suman Sham order came out. So accordingly, I placed that one before the division bench. The division bench say that the question set aside the single bench judgment and for fresh hearing of this case again.
Of these, but these, the judgment of 2015 by Justice Zamir still remains.
Yes, that one has not been appealed. But your lordship, that case, if we read properly, there is not a direction. The order, the court only directs to consider the case of the petitioner only. So whether to consider or not to consider, the option lies with the state government.
And the case, in the case of this Angfai Konak,
yes, your lordship,
this is a case which falls within the ambit of 17.3.
No. So your lordship, 17.
As per this.
As per that's the opinion, that's the view of the judge. So your lordship, this is a perversity, or this is a perverse order. So the state is taking a step for filing an SLP.
Understood. Yes. But the thing is, whatever may be, here it comes within the ambit of the division bench held on the basis of 17.3.
Yes.
That they should have been regularized.
Yes.
And having not regularized them, you could not have deprived them.
Yes.
Here is a case that these people were enjoying a fixed pay.
Fixed pay.
And, your specific case is that 17.3/2015 stipulated the they cannot be considered for regularization and as such no pension because of the fact that they were under fixed pay.
Yes.
The court said that whether on the basis of Jagjit Singh said that the fixed pay question does not arise, they would be entitled to. And on the basis of they being entitled in view of Jagjit Singh, they will be entitled to regularization having completed 30 years. And consequently, it will lead to the next course of action that they will be entitled to pension.
That's what your lordship.
Isn't that?
Yes.
It's a pretty long approach, but that is what has been said. But the first thing is it's a regularization is a scheme of the government.
Exactly, lordship.
And if it is a regularization is the scheme of the government, it has to be within the contours of the regularization scheme.
Lordship,
because what happens by way of regularization, you are taking away the rights of other people who could have been directly recruited and thereby filling up the post. And therefore, in the various judgments of the Supreme Court, it says the regularization process requires a strict interpretation. Your therefore case was there that under 17.3/2015, we only grant only to those fixed pay, we don't grant only for the scale of pay. So it could not have been further extended.
Yes, that's.
So that is why you are saying on the perversity.
Yes. So your lordship, even the present case also, the petitioner knew that he does not come under the scheme of 2004, as well as under the scheme of 2015. He also admittedly saying that. So his only prayer is only under the CCS pension rules. So your lordship, under the CCS pension rule, it applies only to a government servant. And who is a government servant? A person who is holding a post. Petitioner is not holding a post. So your lordship, my prayer is that petitioner does not make out a case. So your lordship, the writ petition should be dismissed. Your lordship, petitioner at the time of his release from service also, he is not the senior most. They stand at serial number 29, some 17, some 18, 19, like that. So if at all, if this court grant allowed the writ petition, then the petitioner will be superseding all his earlier.
First of all, he was on fixed pay.
Yes, he is on fixed pay.
If he is on fixed pay, then where is the question of him being considered under 17?
Your lordship, under the OEM 2004, the regularization policy of the government, if a person is on a fixed pay, if he is the senior most, and if there arose a vacancy, then the fixed pay should be given preference.
Understood, but 2004 notification is no longer there in view of coming into effect of the 17.3.
That is also still in existence.
How can it be? If you see the preface to 17.3 2015 office memorandum, it categorically mentions that in view of this office memorandum or that office memorandum, a decision has been taken by the Work Charge Employees Commission, and on the basis of which all casual and work charge employees will be regularized in the following manner. That's the language.
No, then if we took it that way, then there will be no policy to govern the fixed pay employees, because 2015 is only in respect of the scale of pay. So for 2004 covers the fixed pay work charge employees. The 2004.
Then they will be entitled to regularization in terms of the 2004?
2004, provided that there is a vacancy and the work charge employee is the senior most.
But my lord chair, if you go by the submission of my learned friend, I'm the senior most, so I'm retired. Senior most, so I've served 34 years. Yes.
It stands at serial number 29.
Yes, I'm senior, served for 35, so in that way, I'll be the senior most.
So, Your Lordship, my prayer is that there is no merit in the writ petition, so the writ petition should be dismissed.
No, if that be so, that his case comes under the 2004.
Yes, but he does not come under the 2004. Your Lordship, in my affidavit in opposition, page 6, Your Lordship.
Yes.
Yes, page 6. This is Office Memorandum 22nd September 2004. Policy and scheme for regularization of service of work charge employees. There are a large number of work charge employees.
So there is no age here?
There is no age, Your Lordship.
No period?
Yes.
So then that is only on the availability of vacancies?
Yes. Then, Your Lordship.
So there was no available vacancy?
No vacancy. And at paragraph 4, Your Lordship, the next page, page 7, Roman 4. Work charge employee will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit seniority. This means that the senior most work charge employees in the relevant category will be regularized subject to his or her fitness to the vacant post. So, Your Lordship, only when he is the senior most, he can be considered for regularization.
What was the status of the petitioner then?
Your Lordship, my apology here, Your Lordship, there are a bunch of writ petitions, so I have annexed.
The petitioner stands at serial number 29 in 2019 seniority list
Yes.
of fixed paid labor, and as such his service could not be regular till the date he was superannuated from service.
Yes.
Hence, the petitioner is not entitled for regularization under the policy of the government.
Yes.
If that be so, but otherwise he meets the other criteria.
No, it does not.
Why? It's a fixed pay. You
Yes, a
do.
fixed pay, but there should be essential post.
No, are you doing as per the 50%?
50% we do, yes. Because there are thousands, it will be more than around 10,000 work charge employees, Your Lordship. So each category, the petitioner is a fixed pay labor. So each category will have maintain its own seniority means.
Now, maybe he may not be entitled for regularization, but would he not be entitled to pension and pensionary benefits?
Yes. He's not entitled.
Why?
And he's already retired.
Huh?
He's already retired.
So that is why the pension comes. Huh? You see, why then taking his service for 35 years and then not giving him at least a pension?
He's a work-charge employee.
Understood, to work as employee, but if you are saying that you still continue to have two policies, there's a reason why why are there two policies? You see 2015, let us see the 2015 thing. It is there, kindly see.
Page 8.
Yes, kindly see. On consideration of the report of the work charge and casual employees commission, and in compliance with the judgment of the High Court, the government of Nagaland is pleased to introduce the following schemes for regularization and absorption of work charge and casual employees, and revision of the pay and wages subject to the conditions. It does not mention anybody else. It says all work charge and employees would be regulated by this.
Then
All existing regularization would be now only limited to fixed pay, the scale of pay. Kindly see number 2. Revision of rates of fixed paid, work charge and casual constituent employees, page 10. The rates of wages of fixed paid, work charge and casual contingency employees are revised as under with effect from so and so. Then how do you say that this does not take care of the fixed pay, or the 2004 fifth memorandum still exists?
Lordship may come to page 9.
Page 10.
No, page 9, government 3. This was it. The existing scheme, so that it talks about the 2004. The existing scheme for regularization of work charge employees against normal vacancy is being modified, and the quota for work charge employees stands enhanced from 50% to 67%.
No, in fact, what has happened, there was a judgment of justice of the single judge out here saying that this office memorandum dated of 2015 ceases to exist after the completion of 5 years and reverts back to the office memorandum of 2004. That judgment was set aside by a division bench of me and Justice Sarto, holding therein that 2015, this explanation to this only relates to that for this period of 5 years, the vacancies would be filled at 67%, and thereupon it again would revert back to 50%. So that is therefore it was clear, and it was also mentioned that the 2004 of work charge employee, the office memorandum only survives insofar as it is not inconsistent with the 2015. Now, 2015 also take care of the fixed pay. Kindly see page 10, revision.
Yes, the pay has been revised.
Then if that be so, isn't it the conscious decision of the government that only we are going to take work scale of pay? Because this is a very relevant aspect. You see, the regularization, this is a question of regularization. Can you regularize somebody? It is the government's decision pursuant to an order being passed, on the basis of which the government had taken a decision that, look here, we are only going to regularize the scale of pay. If you have for fixed pay, then it would have a, and if you are continuing, it's a different thing.
Lordship, we are continuing with the 2004 as well as the 2015. The 2004.
So 2004 still continues for fixed pay.
Yes, for fixed, and for 2015 for scale of pay.
then in that case, why we have to look into it, why his case was not considered.
Because he is not the senior most at the time of his superannuation. When he is in service, he is not the senior most. And there was no vacancy also.
Now, if you see one tree of that particular, the existing scheme for regularization of work charge employee against normal vacancy is being modified.
Yes.
And the quota for work charge employees stands enhanced. Existing scheme is 2004. And the quota for work charge employees stands enhanced from 50 to 67%. So thereby you have increased to 67%.
67 for a period of 5 years.
For a period of. Then in spite of that, the petitioner did not come?
No. He does not come.
Or is it because you increased it to 67%, taking into account that the two no, because earlier there was nothing to say about the fixed pay of 2004. It was fixed pay, and then now you are bringing in a differentiation, saying that now also another thing will be taken into account, the scale of pay. So how are you dividing that?
Your Lordship, only when there is a vacancy arose in the post of a labor, then only the senior most can be accommodated. If there is a regular vacancy in a Chowkidar,
so a work charge employee
just to that area,
who is a laborer is not entitled to the scale of pay?
Your Lordship, they are not entitled to the scale of pay because they are not appointed against a post. But earlier when the Nagaland Regulations of Work Charge Employees Regulation Act, during that time some of the scale pay work charge were given scale of pay. So in order to protect those people,
so that will be way less compared to them.
There are many, Your Lordship.
My lord, all the work charge employees have been appointed without sanction post only, my lord. Till today, my lord. So now the state respondent can say that I've been appointed, has not been appointed against sanction post, my lord.
The definition of work charge employees is in the Act. So it says that without holding a sanction post.
Then how are you giving scale of pay to some and not to others?
So those are the people before the introduction of the Act, some were given scale of pay. So even in the Act also it's mentioned in a section in the Lordship in order to.
So those people have come only in 2004.
Prior to that also.
What is the Act year?
2004, yes. But
it's 2004.
Yes.
If it is 2004, the petitioner's hearing was appointed prior to that. So then why not the petitioner was paid?
No.
Because he didn't have the bargaining power.
No.
Something look to that effect. I think there's some serious illegalities.
My lord, it's
Your
out
Lordship,
of
page,
record, but
page 29.
Of your affidavit?
Yes, in my affidavit.
Yes.
Your Lordship, yeah.
2001.
Your Lordship, Section 2D of the Act of 2001 defines work charge employees, which means an employee engaged without sanction post under work charge establishment. As per Section 6 of the Act, work charge employee will be entitled to be paid wages as may be prescribed by the state government on consideration of recommendation by the Commission. However, in case of work charge employees who were paid scale of pay at the commencement of the Act, their pay would not be less than the last pay as may be determined at the time of prescribing the fixed wages. From the above, it apparent that the Act of 2001 seeks to protect the last drawn wages pay scale of work charge employees. Then the second paragraph 15 also regulation.
No, here the petitioner out here did not have the qualifying service of 30 years
Yes,
in this case.
yes.
But in the present cases, the petitioners have.
But petitioner is a fixed pay.
So
fixed
what?
pay. So your lordship, in order to consider his case, there should be a policy, regularization policy of the government.
No, when you
Yes, but
are,
then we did not have
when
that
you are
policy,
still
petitioner will not
having,
be appointed
no,
against that.
madam, but when you are having two scales of pay, two regularization proceedings still going on, then in that case, it is clear that the petitioner has been, rights have been affected under the 2004.
No, petitioner is admittedly saying that he does not come under 2004 and 2015. So he comes under the CCS pension book 1972, your lordship.
No, I never denied I'm not applicable under
Hmm?
2004.
When did you retire, mister?
2019,
19.
2017.
This is as per 2017. Date of joining, and when did the petitioner join? What is the name of the petitioner?
First joining is
Sojiba.
1984.
Sojiba is where? No Sojiba.
Thereof
Sojiba. No, Sojiba is where?
8884, my lord.
Its serial number?
884, my lord.
Page of your affidavit?
My election, my lord.
Of his writ petition.
Page?
Page 10, annexure, my lord. Page number 10, my lord.
10.
Annexure M.
Page 10 is your appointment, annexure A.
Yes, this is my ID card, my lord. So
Then?
as per this, my.
No, where is your serial number?
Your lordship, his seniority.
Yes.
Now, in this affidavit, there is no mention at annexure 3 of your affidavit, page 13. Where is the name of the petitioner?
Lordship, my apology, I have make a mistake in annexing different documents. That document will be in WPC 101, your lordship. I have
101.
interchanged this one with my apology.
Okay. 101.
Oh, WPC 101.
Where is the petitioner?
101, page 13. This
Page
is the
13, 101. Where is the petitioner? 29.
Your lordship, page 13. Ward judge, staff designation wise update seniority list. as of January
84 and 2019.
Yes.
So 19 years, another 16,
Page
35
14.
years.
29. If you read Sojiba, your lordship.
So all these people,
Yes.
none of these people have been granted.
No, lordship.
And why these at
Because,
serial
lordship-
number 909 and 917?
Yes, these are
Like-
also the petitioners here in this bunch of appeal. Page serial
Oh,
number
they are
109.
petitioners.
Recommend.
So all these people have not been granted.
No. Serial number 13, your lordship, 909, he is WPC 103. Then serial number 15 is,
So under such circumstances, the
Yes.
question arises that can you take somebody's service for 35 years and not give him anything?
set, but your lordship, the scheme, the Act of 2001 says that,
Because if he was getting a scale of pay, then he would have taken, if he had retired also.
no, but provided that he has to complete 30 years.
Yes, yes, if he had
If he has
completed
not
30
completed
years,
30 years, he cannot get.
no, if you have completed 30 years, you give them benefit for that,
Yes,
but not in this case.
yes,
Although there is no mention in the 2004 office memorandum
Yes.
that he is not entitled, if he retires, he has to get into that particular thing at the time prior to his retirement?
Say suppose at the time of his retirement, if he stood at serial number 1 and there is a vacancy and department did not consider his case, despite of his retirement, he can always claim for his service regularization and for pensionary benefit, Your Lordship.
My lord,
So we
as
are
per the
given,
OM,
Your Lordship, protecting even the benefit.
But
to
wouldn't
the-
that be two classifications being made
Mm.
that for regularization?
Mm.
On one scale, you in respect to fixed pay,
Mm.
if a person retires after completing 30 years also, then also you are not going to take into account him. Whereas in respect to the 17/3/2015, if a person retires after 30 years, having a scale of pay, after retirement also you'll consider.
Yes, because he
So
cannot
within that
avail-
amounts to a discrimination.
There is no discrimination, Your Lordship. There is no discrimination.
Why? So on the face of it,
In 2004, that regularization.
because
was
your
subject to
2004
vacancy.
office memorandum does not say that a person retiring would not be entitled to regularization even after completion of 35 years.
It talks about the vacancy as well as the seniority position.
The 2015 also says about the vacancy.
So that's for the age, Your Lordship.
My
So
lord.
if a person, if he is lucky enough, before he completed 30 years also, he may be regularized within 10 years or 11 years, Your Lordship. If he stands at serial number 1 after his appointment.
My lord, let me take your lordship to OM dated 17/3/2015.
Huh?
OM dated 17/3/2015, my lord.
Yes.
Clause 1, subclause 1, my lord.
Clause?
Clause 1, my lord.
Ah.
May I read, my lord?
Hmm.
All existing work charge and casual employees of various departments who are enjoying scale of pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their post into regular ones personal to them and subject to fulfillment of conditions and indicated below. So, my lord, once the voucher, even if the person is enjoying base scale of pay and regularized, that the post held by that very person will be personal to them. So there won't be any vacancy, my lord. Vacancy will not created at all, my lord. Now, my learned friend has submitted if there is vacancy or
No, I'm
vacancy has
talking
been
about the
created.
fixed work charge, not about the
So-
scale pay.
So
you're
scale of pay,
he
they are
says
also a scale of
fixed
pay.
pay.
Unless they are regularized, they are also a fixed employee, my lord. Work charge employees, my lord. Until they are regularized, even if they are enjoying, they are also work charge employees. Work charge employees. So as per this OM, if a person is retired, that very post is personal to him, and post will never be created, and the rest who are in the scale of enjoying fixed pay will never have an opportunity to regularize or receive scale of.
That is why I'm saying, how can you have two policies? The government says that they have still two policies. You see, that is the problem you are having. You can't have two policies, but you are having two policies.
For fixed and for
And if
scale.
you are having two policies, why not both are having the same thing? A person who retires in between after to 30 years, but having a scale of pay, you are giving a particular benefit. Although that scale of pay was given by the person concerned, which he should not have given. And on the other hand, a person who is in fixed pay, even after completing of 35 years, he would not be entitled to. Wouldn't that be an apparent violation
No,
of Article
Lordship,
14?
Even as a scale of pay.
And on one hand, here in this case of 2015, you are saying that a person having, it will be personal to him. That means you will create a particular post only for him, personal to him, and thereupon once he retired, the post ceased to exist. Whereas you are not doing for the fixed pay. So why?
Where will the post come? That is the question.
Isn't that an amount of violation if you have these two policies, unless the policy of 2004 is overridden by the 2015? Otherwise, on the face of it, there is an apparent contradiction or apparent violation. Has she stated in the affidavit that both the policies coexist?
Lordship, I have stated in my affidavit that Lordship, page 3. So I stated that second paragraph. Second paragraph, the petitioner was overcharged fixed pay labor and released from service on superannuation on 31/8/2019. The petitioner did not come under office memorandum.
No, understood, but you have not stated that both the policies coexist.
Yes, the petition, yes, coexist.
You file an affidavit on your state. We will take it up then. Then because then we can very well go into, and then you file an additional affidavit, bringing into the point that it is on the violation of Article 14. Okay? Then you may have a good case. That is the only way out. Well, apparently it seems so. Because if they say that both the policies coexist, then it cannot be that a fixed pay is given a different thing. Because it was a fixed pay or scale of pay at that point of time which was granted by an executive action, not on the basis of any law. So under such circumstances, a person who is enjoying a fixed pay would be entitled to the benefit even after his retirement, whereas here he is not. So why can't a supernumerary post be created for you for granting it and thereby grant the pension?
And your lordship, in this case also that Nishibi's case, the principle of law, so it's very clear that when the petitioner during his lifetime he has not applied for regularization of his service.
If you see Nishibi's case, Madam, kindly see the judgment. I'll show you where is that Nishibi's case. Where is that? Kindly come to paragraph this one. 15, page 30 of your affidavit. Yes, read it. There can be no doubt about the fact that with the enactment of Iman, the conditions of service of so and so in different works in the would be governed by the provisions of it. Neither confers any right to seek regularization in service, nor does it extend pensionary benefit to area, unless a worker is regularized against a vacant sanction post and fulfills the minimum requirement of minimum qualifying service as a regular, the question of the payment of pension would not arise in the eyes of law. In the present case, even if expect post facto regularization is given to the petitioner, even then he would fall short of the minimum qualifying service under the rules so as to entitle him to receive pension.
Yes.
So under such that person concerned is there. But a question out here is whatever may be, you are having, if you see one IF of the 17/3/2000, it will, the qualifying service will be regulated as per your 2009 Act. That is why I put that specific question in the earlier matter. You were there. Not here. There was another counsel who was there, no? And you have assisted and shown him that clause 1IF. So that is where by which the qualifying service is being taken out of. But be that as it may, here is a case that the petitioner here is otherwise qualified. Anyways, from a perusal of the materials and record and hearing the learned additional AG, it transpires that both the office memorandum dated 22/9/2004 as well as Office memorandum dated 17/3/2015 coexist. However, as the same is only a submission, this court would like the same be put by way of an affidavit by the Commissioner and Secretary to the Government of Nagaland PNR Department. List the matter again on
Lordship, after 3 weeks, Your Lordship, for
Okay.
this matter.
on 1st of April 2024. The affidavit be filed by 22nd of March. And the petitioner thereupon shall by 22nd of March. Yes, have you got your instructions? That
Your
matter,
Lordship, let me, I was taking the keys and in the meantime, the phone.
okay, I'm coming in 5 minutes.
No, usually admission, daily course list, schedule will continue till supplementary. Then come back to orders, daily, then go to supplementary order.
Lordship, I asked the officer, then they were saying that the NPS, what they have been deducted, that will continue. Right now, also after the mainstreaming, also it will continue, Your Lordship, yes. And regarding about the recovery, they say that it's a mistake, and the Supreme Court also there is there also for recovery to make
They
it-
would not recover any amount, but they will readjust.
Yes, yes.
Chalo, we dispose of all these matters now.
Much better.
The instant batch of writ petitions are taken up for disposal by this common judgment in order. Taking into account, taking into account the similarity of the issues involved and similarity of the facts and the issues involved. Heard Mr. Joshua Seki, the learned counsel appearing on behalf of the writ petitioners in the batch of writ petitions, and Ms. So-and-so appearing, the learned AAG appearing on behalf of the state respondents. In the instant batch of writ petitions, the petitioners herein have assailed the order dated 2/9/2022, the notification dated 2/9/2022, whereby to the limited extent whereby the petitioners, the seniority of the petitioners who were in 2010, who were recruited in 2010 and 2013, have been placed below the teachers appointed on regular basis or whose services have been regularized. The interstate seniority list has also been assailed. Whereby the petitioners seniority position have been put below the teachers who were appointed on regular basis much after their recruitment in 2010 and 2013. Much after their appointment orders pursuant to the recruitment done in the year 2010 and 2013.
Your Lordship, as far as the seniority list of 2022 is concerned, for both the GT as well as the PT, our names are not included.
Lordship, I have stated that that seniority of 2022 that pertains only to the person who were appointed before 2009. Before 2009. So petitioner is appointed after 2010, so his name will not be there.
It's okay. From the record, it reveals that on 2010-2009, by the notification, (210) temporary posts of graduate teachers bracket non-gazetted for 70 government middle school under the school education department at the rate of 3 teachers, that is 1 teacher each for English, science and maths for each school. As indicated in the enclosure attached to the in the pay scale of rupees 5,000-150-8,000 per month. Along with other allowances as admissible under the rules in force in Nagaland from time to time were created. From the said notification, it further reveals that the expenditure was debitable to the head of account 2202-01-0101 bracket 1 under the plan CSS expenditure. What is CSS?
Central Sponsor
Sponsor
Scheme.
scheme.
The terms CSS being relevant in as much as the said term categorically stipulates central sponsored scheme. Clause 3 of the said notification further stipulates that a post of teachers would continue to function even if the Sarva Shiksha Abhigyan SSA program is wound up and the following procedure would be followed for payment of the salaries. The procedure mentioned therein being relevant is yeah. And a set of procedures would be followed for payment of the salaries. It has also been mentioned in clause number 4 of the notification that the said creation of the post was issued with the clearance of the PNR department, approval of the cabinet, concurrence of the finance department, and clearance by the planning department. Taking into account the relevance of the said notification dated 20/10/2009, the same is reproduced hereunder. That is at page 12A of this affidavit. Affidavit of respondent number 1 and 2. Only from Government of Nagaland to the Additional Chief Secretary. Copy 2 not necessary. Subsequent thereto, on the same date, another notification was issued bearing number EDS/SSA-CPA /009-2008 Roman 2 containing similar conditions, but was in respect to creation of 268 temporary posts of undergraduate teachers, non-gazetted. The record further reveals that on 21st of March 2011, the governor of Nagaland further created 2,606 posts, temporary posts of teachers under the Sarva Shiksha Abhijan, under the Department of School Education Nagaland. In terms with the said notification, dated 21/3/2011, 1271 posts of teachers against 1007 primary schools and 1335 posts of teachers against 449 middle schools under the SSA program. The same notification dated 21/3/2011, being relevant, is reproduced hereunder, page 15A. Subsequent thereto, by another notification dated 15/6/2011, bearing notification number DSC/RS/2011, another 482 posts were created by the governor of Nagaland under the Department of School Education (RMSA). The same notification categorically mentions that the planned expenditure under the Rashtriya Madhyamik Shiksha Abhijan the head of the pay and allowances would be drawn from the Department of School Education under the Rashtriya Madhyamik Shiksha Abhijan under the CSS expenditure. The same notification being also relevant is reproduced here in under. From the aforementioned notifications, referred to here in the aforementioned notifications, it would be seen that these posts were created and sanctioned by the governor of Nagaland in respect to the schemes, central government sponsored schemes, being the Sarva Shiksha Abhiyan and the Rashtriya Madhyamik Shiksha Abhiyan, bracketed SSA and RMSA. Be that as it may, on the basis of the creation of posts by the aforesaid notifications, advertisements were issued by the Director of School Education on various dates, and on the basis of the said advertisements, recruitments were carried out, wherein the petitioners, along with others, were duly appointed as graduate teachers and primary teachers. And what else, Mr. Joshua?
His Lordship,
What
since
are the
both the
teachers?
petitions are, both categories of the petitions are clubbed together, as graduate teachers and as primary teachers.
These are only two.
Yes, Lordship.
As graduate teachers and primary teachers, the petitioners thereupon, after their appointments, were allowed to subscribe to the new pension scheme,
Yes, Lordship.
to the pension scheme of the government of Nagaland.
Yes, Lordship.
And thereupon, they continue to render their duties. Full stop.
First, Lordship, before the pension scheme, the service book was maintained for all the petitioners and the new pension scheme.
It is also been stated that the service books were also maintained of the petitioners as required for the teachers working in the regular cadre of the government of Nagaland.
Yes, Lordship.
Thereupon, on 2nd of September 2022,
My Lord, may I also kindly mention the MSCP for the 2010 batch, which is approved in 2021. MSCP 2021.
that
Hello.
I'll come to that. Thereupon, on 2nd of September 2022, on the basis of a decision taken in the cabinet on 21/4/2022, the a total of 2290 teachers appointed under the Sarva Shiksha Abhijan and Rashtriya Madhyamik Shiksha Abhijan of 2010 and 2013 were brought within the fold of the state education cadre with effect from 21/4/2022. And it was mentioned, and in that regard, a notification was issued on 2/9/2022, wherein it was also mentioned that the seniority of these 2010 SSA batch and 2013 SSA and RMSA batches shall be parked immediately below that of the teachers already appointed on regular basis or whose services have been regularized. On the basis of that, the said notification dated 2/9/2022, the interstate seniority list was also prepared, by which the seniority position of the petitioners were also reflected in terms with the office memorandum dated 2/9/2022.
My lord, there's a slight variation between the graduate teachers and the primary teachers. The graduate teachers, the seniority list is 27/9/2022. And for the primary teachers, the seniority list is dated nil June 2022, Lord. The present petitioners, both graduates as well as the primary teachers, they are not included.
Now, what is this seniority list at 397?
No, no.
What is that seniority list?
What's it, the seniority list of the graduate teachers? I'm referring to the writ petition number 311 of 2022 at page 395, annexure 124.
397. 397.
395, Lordship.
395 is the notification.
Yes, Lordship.
What is 397?
Yes, my lord. That is the.
This is after. This is after the. This notification is pursuant to the final seniority list.
Yes, Lordship. For the primary teachers, I'm referring to WBC number 299, Lordship. 299. At page 33, annexure 13. This is press release / circular dated Kohima the nil June 2022. The seniority list of the primary teachers, Lordship.
There is no notification like this in 27/9/2022 for others.
Yes, for the former primary teachers, it's mentioned as press release / circular, June 2022, dated nil.
No, it couldn't have been. After that, there has been, madam, there's no seniority list after that.
Lordship, right now, this one has been mentioned as a tentative seniority list.
Now, was there any seniority list after 1929?
Regarding with the primary teacher, I have no knowledge, Your Lordship.
Okay.
But in regard to the graduate, Your Lordship, it
No, there
is
is
first phase-wise we are doing.
Okay.
Phase-wise.
Then, on the basis of the said notification dated 2/9/2022, a notification was issued on 27/9/2022, where the final seniority list of graduate teachers of elementary and secondary grade under the school education department as on 1/9/2022 was notified. petitioners herein being aggrieved by their seniority position in view of the notification dated 2/9/2022 have approached this court by filing the batch of writ petitions. The record reveals that this court, pursuant to filing of the batch of writ petitions, had issued notice, and the respondents have filed their affidavit in opposition, stating inter alia that the appointments so made to the petitioners were under the scheme, under the centrally sponsored scheme, that is SSA, full form to and RMSA. And as such, it was on account of a cabinet decision taken on 21/4/2022. The petitioners were brought within the fold of the state of Nagaland's regular cadre. Under such circumstances, their seniority has to be taken into account on the basis of as on when the petitioners were brought within the fold of the general cadre of the state of Nagaland. And in this case, taking into account the cabinet decision, the petitioners were brought within the ambit of the state cadre with effect from 21/4/2022. In the backdrop of the above facts, this court have heard the learned counsels appearing on behalf of the petitioner. In the backdrop of the above facts, let this court take note of the respective submissions made on behalf of the petitioner as well as the respondent. Mr. Joshua Saki, the learned counsel appearing on behalf of the petitioner, submitted that the governor of Nagaland created posts, and on the basis of those creation of those posts, the petitioner was duly appointed. The learned counsels therefore submitted that as the posts were created by the state of Nagaland, the appointments made thereupon has to be construed as appointments made to the regular cadre of the government of Nagaland. He further submitted that not only that, the respondent authorities all along had treated the petitioners as belonging to the regular cadre of the government of Nagaland, taking into account that the NPS, the petitioners were allowed to subscribe to the pension, and also some of the petitioners have been granted the modified MSCP, modified assured progression scheme.
Career progressive scheme.
He therefore submitted that in the instant case, the petitioner therefore could not now be again turned to come within the cadre of the regular cadre of the state of Nagaland, taking into account that the petitioner all along from the date of their appointment have been within the regular cadre of the government of Nagaland, and the said period. Anything else?
My lord, the proceedings before is on the court also. The state has maintained a position that we are part of the state cadre.
He further submitted that not only the state government, the officials of the state government have treated the petitioners in the regular cadre of the government of Nagaland, but also it is their specific case in the earlier round of litigations that the appointees in the 2010 and 2013 batch belong to the regular state cadre of the state of Nagaland.
My lord, and one more point, if my lord may kindly. In 2015 seniority list, the 2010 batch were also included in the seniority list. Now we're out.
That I'm not going to say because that seniority list does not require.
Lord.
He further submitted that as a consequence of the said notification dated 2/9/2022, whereby the petitioners now have been brought within the cadre of the state education cadre with effect from 21/4/2022, not only would affect the petitioners' rights which have accrued on the basis of subscribing to the pension policy of the government of Nagaland, but would also take away certain benefit, would also result in recovery proceedings in respect of those teachers who have already been granted the MSP.
My lord, that is not my submission, if my lord.
No, this is required. Then only I can protect you. If you
Let them
don't
try,
do it
lordship.
tomorrow, there will be recovery proceedings.
Lord, if my lord may kindly appreciate there are legal remedies for that also, let them try, lordship. I have no issue with that. But if my lord may kindly excuse me from that submission not being part of my submission, my lord,
Which one?
about the benefits, the recovery of the benefits enjoyed, lordship.
Are you not submitting about MSCP?
My lord.
The moment you say about MSCP, the question, therefore, the next consequential effect is the recovery. They will make a recovery. When I am doing it in your favor, why are you referring?
Lordship.
If you don't do that, tomorrow they will go for recovery against these people. The moment I dismiss this, they will say that the MSCP, which you are saying that they were given MSP.
No, lordship, everything is the creation of the state. The state has to own up its own responsibility. And
That
their
is why
responsibility,
the
lordship,
court has to say to that effect. Or I may say that you don't want to have any problem with the recovery. Then I will say.
No, lordship, I'm not saying that, but the submission which I have not
Then
made.
you have to leave the MSCP thing from your submission. Are you going to make the submission? That leave out the MSCP. The moment you say about MSCP, the question arises that tomorrow the state will make a recovery. Can this court shut its eyes on this? Don't make a submission on MSCP. I don't bring it. I will only say about the pension.
Lordship, since I have placed the record that the 2010 batch has been granted MSCP, and that is only for the regular employees, lordship. And that has also been the consistent opinion of the state before this.
Mr. Joshua, do we know the next course of action? The moment I dismiss it, you'll be directed for recovery, which will lead a lot of problem to all these petitioners. You have to understand the plight.
If there is no direction for recovery, lordship, I don't think the state will do that. It's their own action, lordship. They have to own up to their own responsibilities. Everything is a creation of the state, lordship.
That is why I sought for the instruction where she said from instructions that they are not going to make a recovery. If that is there in the order, how is it going to harm
My
you?
lord, respectfully, my lord.
Only thing is that you may lose some clients.
Now, if it becomes my submission, not for recovery of the MSCP, lordship, if that becomes part of my submission, then, my lord, if the matter has to go on appeal, it would be like cutting off part of my own tongue, lordship.
Why?
Because it is the state who has given us. I've just shown the record before
No,
you,
no,
lordship.
you are not saying.
Yes, lordship.
Your submission, therefore, is that look here, if you today, if I don't interfere here, they will tomorrow recover. That is your submission. I'm not saying that they are going to make a recovery. No. Read it. What did I say?
Not only to affect the petitioner's right, which have accrued on the basis of policy government, but to also result in recovery proceedings in respect of those.
That is your submission. If this, I don't interfere, don't interfere with this. Because tomorrow they may take action against you. And as such, I should not interfere. I should interfere with this. And giving you seniority from there.
Madam.
This is in your interest only. On the other hand, Ms. So-and-so, the learned AAG, submits on the basis of the affidavit in opposition, stating inter alia, submitting inter alia, that from the notifications on the basis of which the posts were created, it would be seen that the posts were created in respect to centrally sponsored schemes. The payments were to be made by the central government. Under the SSA or under the head of accounts created on account of in relation with SSA and RMSA. And as such, the posts which were created could not have been a post within the state education cadre until the cabinet had taken a decision on 21/4/2022 to bring these 2,290 teachers appointed under the SSA and RMSA of 2010 and 13 batches to the state education cadre. The Learned Council further drew the attention of this court to the judgment of the Supreme Court in the cases of Dhyan Chand and others versus State of Haryana and others, reported in 2002, 10 SCC 656, as well as the judgment of the Supreme Court in the case of the other one, 2020, 12 SCC
131.
Have it? As well as the judgment of the Supreme Court in the case of Parmeshwar Nanda, or what is that? Parmeshwar Nanda and others versus the state of Jharkhand, reported in 2020, 12 SCC 131. This court had also put a pointed query upon the Learned Council appearing on behalf of the state, Learned AG appearing on behalf of the state respondents, as to what would be the fate of the petitioners herein who had subscribed to the pension scheme. In view of the notification dated 2/9/2022, whereby the petitioners herein were brought within the fold of the government of Nagaland, the state education cadre, only with effect from 21/4/2022. Further to that, this court had also put a specific query upon the learned additional AAG as to whether the petitioners herein who have already been granted the benefits of the petitioners herein who have been granted petitioners herein, and more particularly to the batch of 2010 who have been already granted the MACP, would be deprived of their benefits and recovery proceedings should be initiated against them. To the aforementioned two specific pointed queries, the learned additional AAG submitted upon instructions that the petitioners who have subscribed to the pension scheme, the benefits in respect to the benefits which had already accrued to the petitioners on the basis of the said subscription would not be disturbed. Madam, benefits which we have accrued to the petitioners
Yes.
who have subscribed to the pension scheme would not be disturbed. We are not going to disturb the
Regarding the MACP, yes.
pension
That will continue, that will continue.
would not be disturbed,
No, she-
would not be disturbed. On the question of the grant of MACP, the learned AAG submits that none of the petitioners have been granted the MACP to her instructions.
As per the report, some has been given, but that is by mistake, Lordship, because.
No.
Yes.
None of the petitioners ought to have been granted the MACP.
Yes, ought to have been.
And if it was given by way of mistake.
Yes, Lordship, yes.
Submits that none of the petitioners ought to have been granted the MACP, the benefits of the MACP, taking into account that they were not government servants
Yes.
under the state education cadre till 21/4/2022. And if in the meantime some of the petitioners were granted, the same was granted by way of a mistake committed by the officials. This court, upon hearing the learned counsels, this court have duly heard the learned counsels appearing on behalf of the parties.
I beg your apologies, my lord.
Yes.
If my lord may kindly reflect the judgments that I have placed before your lordship, the authorities.
Which one?
My lord, I have already placed 2011 5 SCC 435, para 11 and 12. Lordship on 2 points, approbation and reprobation, and the federal post lordship.
Where are the judgments? 2011.
2011 5 SCC 435, para 11 and 12. There's also an approbation and reprobation lordship. 2026 SCC 387, para 26 and 27. 2022 SCC, para 52, page 52, para 16 to 18.
Then
And my lord, on the direct recruits lordship, which my lord was mentioning the other day, 1992 SCC 715, para 47, 2022 6 SCC 105, para 21,
What is 2022?
Lordship, from the date of their initial appointment, the seniority to be counted, Lordship.
But the initial appointment has to be from the day, from the
No,
cadre.
Lord, I'm placing the authorities, Lordship. That is my submission. So in support of my
Understood,
submission,
but
yes.
what is 2020-19 SCC? You have given the submission, yeah. তার আগতে, লিখিত আগতে, our submission.
My lord.
In that regard, Mr. Jace, the learned counsel for the petitioner had submitted the following judgments. Number one, Amrendra Kumar Mahapatra and others versus State of Odisha and others, reported in 2014, 4 SCC 583, para 70. Shiraz Ahmed, number 2, versus State of Uttar Pradesh and others, reported in 2020, 19 SCC 480, para 19 and 20. Union of India versus Manpreet Singh Poonam and others, reported in 2022, 6 SCC 105, para 21. Joint Action Committee of Airline, number 5, Joint Action Committee of Airline Pilots Association of India, bracket ALPAI, bracket close, and others, versus the Director General of Civil Aviation and others, reported in 2011, 5 SCC 435. Para 11 and 12. Bhagwat Saran, bracket dead through legal representatives, bracket close, versus Purushottam and others, reported in 2026 SCC 387. Para 26 and 27. ABCD versus Union of India and others, reported in 2022 SCC 52, paragraph 16 and 18. And the direct recruit class, Roman 2, Engineering Officers Association versus the state of Maharashtra and others, reported in 1992 SCC 715, paragraph 47. In the backdrop of the in the backdrop of the above submissions, let this court take into consideration. Let this court analyze the facts in the analyze the facts. From a perusal of the notifications by which the posts were created, the reference of which have been already made, supra, it would clearly show that the creation of the post by the governor, the creation and sanction of the post by the governor of Nagaland, were in respect to posts which were centrally sponsored schemes. Under the Sarva Shiksha Abhijan and Rashtriya RMSA full form. The said notifications categorically show that the creation of those posts, that the funds in respect of the funds on the basis of which the salaries would be disbursed would be on the basis of the said schemes. Before further proceeding, this court finds it relevant to take note of that the Sarva Shiksha Abhijan is a government of India's flagship program for achievement of universalization of elementary education bracket UEE bracket close in a time-bound manner as mandated by the 86th Amendment to the Constitution of India, making free and compulsory education to the children of 6 to 4 years age group a fundamental right. The said SSA program is being implemented in partnership with the state governments to cover the entire country and address the needs of millions of children. The RMSA, the Rashtriya so-and-so, is also a Government of India flagship program in relation to providing quality education in relation to providing secondary, it's secondary, na? A middle school. RMSA is?
Both high school and elementary, Lordship.
No, elementary,
Or
elementary is
RMSC, Lordship,
SSC.
my lord, RMSC is for the high school.
Secondary, high school. Above 14.
Yes, yes.
Because SSC comes under,
Yes, my
now
lord.
therefore we
Yes,
have the server,
No,
now we have the Sarvajana Siksha, which both RMSA and MSA SS has been, which is a flagship program which aims at providing education in the high schools in the country. On the other is a Government of India flagship program envisaged for establishment of new secondary schools, upgradation and strengthening of existing upper primary, secondary schools, improvement in quality of education by providing libraries, laboratories, furnitures, etc. The same scheme was implemented. The same scheme has also to be implemented under the aegis of the Ministry of MRD, Ministry of Human Resource Development of the Government of India, and implemented by the state governments. In the state of Nagaland, the SSF program scheme was implemented sometime in the year 2009.
Yes, Lordship, yes.
And in respect to the RMSA, was implemented from the year 2010. It is on the basis of the implementation which was taken up by the state of Nagaland. These posts were created by the various notifications referred to in the earlier segments of the instant judgment. Under such circumstances, as the creation of those posts were on the basis of the scheme of the government, the question arises as to whether the said posts which were created could have been treated as posts falling within the state education cadre. Yes, others may go. Because this, another 15, Mr. Joshua has referred to a lot of judgments, so I have to refer to that. In the above, to decide the said question, this court now finds it relevant to take into account the judgments submitted by the learned counsels on behalf of both the parties. The judgment in the case of Dhyan Chand Supra is a case wherein the petitioners therein where petitioner therein was recruited to the regular post under the state government. And thereupon the petitioner claimed that his service for a number of years rendered under the Rural Education Literacy Project / State Adult Education Program should also be taken into account as his qualifying service. The Supreme Court in the said judgment categorically observed that the petitioner therein, though rendered service as supervisors in the adult education scheme, but the said service rendered under the said scheme could not be taken into account for deciding their pensionary benefits or even for fixation of the salary in the scale of pay once they were regularly absorbed. It was categorically observed by the Supreme Court that the such schemes are taken up for that continuance of engagement under specific schemes cannot be held to be an employment under the establishment of the government, inasmuch as such schemes are taken up for certain contingencies when money for the same is provided either by the central government or at times by foreign countries. It was also observed that the employment under such scheme not being a part of the formal cadre of the state government, it will be difficult to hold the period for which an employee rendered service under the said scheme can be counted either for the purpose of deciding their pensionary benefits or even for fixing of the salary in the scale of pay once they are regularly observed. Oh, yes. Tomorrow I'm sitting. I have a meeting, so I'll do one thing. I will, tomorrow I give the remaining part in the court itself. But this is it. Or should I complete it by myself?
Simply by yourself.
My lord.
I'll show you disposal. You see, this is it. I'll deal with your judgments. You have unnecessarily harassed me with these judgments.
It is my responsibility, my lord.
Yeah,
I have
that's
2,000, more than 2,000 people behind me, my lord.
Understood, but can't help it. Anyways, so because I have to, anyways, I'll deliver the judgment.
My lord.
Taken and disposed of. But I will say out there that whatever may be, the benefits which they have brought shall not be curtailed in respect to those pension schemes. If they have subscribed, that will continue.
Yes, yes.
And if the petitioners, some petitioners have been granted any MSCP, if here, no recovery proceedings should be initiated against them for that. However, you shall be at liberty to refix their scale as per whatever as on 21/4/2022, taking into account 21/4/2022 as the date on which they have been brought within the cadre of the government, but not to recover.
Much better.
Bless you, lord.
벌지도 왜 보고 아들이